petition for maintenance, execution has been filed and it has been proceeded with by the learned lower court.
Stay of what?
Stay of the
Maintenance.
Final maintenance.
By this court?
Yes. Interim stay is there. But the execution was filed and it has been proceeded. 18th is the date he has told to issue warrant if the money is not deposited.
Told and doing a lot of difference.
Last date we had moved.
In the maintenance, the courts do like that. Only to threaten to get some money to pay. Don't worry about it. We'll see.
18th.
I'll do. Give the memo. We'll see. Yes. Any out of list mentioning? Out of list mentioning. What? Wow, out of list. Okay. Yes.
We mentioned from item 1 to 6.
Yes.
7 to 19.
Item number 7. This matter, my lords, was there before your lordships yesterday, my lords.
Yes.
It has
Again wrongly listed.
Can it be?
See, I asked him to go and tell him, and he insisted, and they.
So can it be listed today? That's why we are mentioning at the first hour.
I can't do it. That's the whole difficulty.
But then let it be released so that we can make a mention now.
Right now, just now. Go and mention that.
Because we are in difficulty.
Don't waste time. Send it. Immediately send it.
We are great.
Okay, you please do that. Yes. Yes.
Item 81.
1 minute. I'll just go through. Yes.
20 to 36. 37 to 51. 52 to 55. 56 to 61.
Yes.
My lord, item 60.
Give the memo.
My lord, item 60.
60. Yes.
May I pray for adjournment, my lord?
Okay. Adjourn on request. 60. Okay.
62 to 67.
No, item 64. I pray adjournment, my lord.
Okay.
68 to 72.
My lord, item 68, my lord. I have, by your lordship's order, I have filed the requisites in time. But my lord, I have filed an IA to implead the opposite party, informant as opposite party. But that IA has not already been filed. But it is mentioned in the order sheet, my lord.
Let it come, then I'll just see.
Okay, okay,
I'll pass that on.
Obliged.
Even if I is not there, I'll pass it on.
IA is there, my lord.
We'll see. Yes. Yes.
73 to 76.
Item 70.
70. Yes.
It's a covered case, your lordships. 5
Covered case.
orders passed by your lordship. Covered. In
Yeah.
2 out of my own case, I have
Same FIR.
same FIR. Lordship passed the order where I had appeared. That is clear. In both the cases.
You are saying that you have committed mistake. If you commit 5th time, you again commit the mistake. That's what you want saying.
Can I make that contention? I can't think that.
That's all. Yes.
That item 1 is there.
I'll just come. Yes, it is allowed. Huh? It is allowed.
Grateful,
Yes.
grateful. So urgent copy of your lordship.
Yes. 71, na?
70.
70 or
70.
2 matters. All the
Matters there in 70. Grateful.
73 to 76. 77 to 84.
81.
yes.
81 is my lord. Today for the 4th time making mention for listing the matter for fresh admission because of the urgency. Your lordship allowed previously your lordship allowed my mention to be listed for fresh admission so that it can be disposed of because the 81 serial the time
What do you want?
for taking of the matter.
I'll take up definitely. And today it will reach. Don't worry.
Item 70.
I think it will reach.
I beg your pardon, lordship.
Minor matters. It will reach.
Item
If it doesn't reach, then 2 o'clock you tell me. I'll take up. Okay.
Item 79, my lord.
Big-
That matter relates to departmental proceeding and criminal proceeding. That is, judgment is
I'll
pending.
just adjourn it. Simply adjourn. Yes.
Beg your pardon, Lordship.
79. Yes.
Item 77, Lordship.
71. Yes.
Praying for adjournment, Lordship. IA is there. Interim order to be continued. DPO.
What is this entry model?
Lordship, further step further proceeding, Lordship.
Oh, that's the problem. You take interim order, then ask for adjournment. Why are you seeking adjournment?
Lordship, our senior is not present today, Lordship, due to some personal difficulties, Lordship, he is out of station, Lordship. On behalf of Mr. Chan, Lordship.
When interim orders to be taken, you will be in the station. Once an interim order is granted, then you go to arbitration. Not dead.
Lordship.
Begging my lord's pardon, my lord. Item 66. Today I am appearing by way of filing Vagalatnama. I pray any other date, my lord.
So at the
I am informed the petitioner.
opposite party.
Only
My lord, short date may be fixed, my lord.
Yes, opposite party
Item
number 2.
66, my lord.
Gentlemen, for filing the response, leave the matter. Yes.
oblige, my lord.
Yes. Then,
The order to be there.
73 to 76.
इसकी चेंज हो सिक्स तो चेंज हो पहले चेंज हो
91. All connected 7 matters are adjourned to 31st. You are still adjourned to
31st, please.
31st. Interim.
Increment.
94 to 100.
97, this matter your lordship has heard it. And I was directed to find some decisions, that land acquisition matter.
But I received a copy, my lords. This is that matter, 2 persons, the same locality, my lords.
I'm submitting a brief note with the decisions.
Let it come, then I just refresh mine. Let it come. One minute, yes. Yes.
The one.
The one name only to be para 6 in place of the council, the same relief into only lordship see para 6 only name and para 8 the date to be the same
Your lordship.
Not
directly in that Delhi or special granted, he has paid the some of the this person in equity.
same of the Mr. Palit was
The passing of provisions.
What are they?
Your lordship
Yes.
is the disposal of directly.
coordinate basing on the coordinate base. Same PS case.
NVW has to be cancelled.
Yes, that is not cancelled. That was the same order, the same accused. Pradeep Jain, I was lordship.
Shall be kept in events.
That
That's
is
what I
the
said.
same order. I have nothing prayed more.
Same order.
Same order.
The
Only para 6, Mr. Palit name has to be changed. Only
para 6.
6. Para 6 only Mr. Palit name is to change, and para 8 also the date of surrender your lordship may fix to as your lordship pleases.
Para 8.
Para 8 the 4th line.
That is 31st.
As your lordship pleases.
31st January.
8. That's it.
31st January, Mr. Palit Jagare, Mr. Lolik Mishra. Okay. Baki, everything is same.
Everything same. That is obliged.
Item 2
Had the matter raised, the admission matter. And the fact is that the man from Delhi had gone to immigration and without any rhyme and reason, he has been arrested. And there also was the proceeding and the last attention, my friend has taken to obtain the case there because what is the
Yes.
is directed to obtain Mr. I obtained, but he has sent the wrong city 69.
Everything case diary.
By 25th.
We'll give it. Yes.
Item 3.
Item 3, may I please your lordship. The case has been registered for the offences of murder on dated 1 March 2023. The counter affidavit has been filed by the state opposite party on 19 September 23, your lordship. On the basis of the counter affidavit, we have filed a rejoinder to that effect. We had already served the copy yesterday.
What do you want now?
We want the matter to be handed over to the CBI, your lordship.
Now,
because-
302.
Because, your lordship, the main grounds is that there is a faulty investigation committed from the part of the police officials, your lordship, because there is a ligature marks was present at the middle portion
That's
of
the
the
reason they registered a case of 302. What do you want?
302 accused. Till now, your lordship, the accused persons are remaining scot-free, your lordship, because Because Lordship, may I be?
Hmm.
I have already served.
Yes.
I'll be serving you another copy then. It's serving you.
No, I am the head of help with that. Okay, I'm now the time.
And they filed the charge sheet for 302.
No, Your Lordship, they haven't.
Just now you said.
No, sir. No, Your Lordship, they have not supplied the charge sheet to the court yet. They have not filed the charge sheet. Lordship,
1 minute, yes.
Kindly see the response. He has subjected to person, and his daughter has been killed by 2 persons. One of the person who is the boyfriend of that girl was died, falling down from that Hirakud Malad.
Who is now investigating? Who is now investigating?
Investigating SDPO Burla.
Okay. Yes.
Then your lordship may respond. Every step has been polygraph test has been done to that accused person who is suspected as accused persons. And my lord, she has doubt everything, my lord. Postmortem report has conducted and the postmortem, he also doubt that postmortem is not correct. Thereafter, my lord, that was sent to.
What do you want?
Your Lordship, kindly have a glance to page number 24.
And I have seen it.
Counted, Your Lordship.
The
There is a
police has done it's
no, Your Lordship.
it cannot be to your satisfaction, but everything, all possible steps has been taken.
Maybe
What
permitted.
else you need?
May be permitted to submit, Your Lordship. Only 2 minutes. At page number 24, there is an external injury. There is a 6 number of red marks in the lateral right side breast with red color dry stabs. There is a faint red color abrasion in the middle portion of the leg, Your Lordship.
Then
So
it's an
as per the medical jurisprudence,
according to your choice, the police will not do it.
no, Your Lordship. I appreciate Your Lordship's concern, but we are relying on the medical.
In the case of 302, they have done it all possible things they have.
Your Lordship, the police officers have released the accused persons on 41A bail, Your Lordship. This is a faulty part.
You challenge that order.
Your Lordship, this honorable court has the ample power to exercise
Ample
the
power is all
jurisdiction.
right, but the court is not here to regulate the investigation.
No, Your Lordship.
Investigation has been done. You are trying to regulate it.
No, Your
You want,
Lordship.
according to your wish, everything else.
No, Your Lordship. We are not trying. We are not
The
putting-
investigating officer is a senior officer. He is doing his job. He
Lordship,
will not get guided by you or me, for that matter.
Your Lordship, but
It is
20.
302 case 3. The investigation is over and 302. They will file it. The charge. That's what he's making.
Your Lordship, what happened is that it's a 23-year-old girl. After that,
You want whoever you suspect has to be hanged before the investigation.
No, Your Lordship.
That's
I'm
what
not saying that. I'm not saying that.
That's
What I was saying is that taking into consideration the exceptional circumstances, this honorable court has the ample power to hand over the case to the independent agency. Your Lordship.
Then you just see who is investigating right now, who is supervising, who is supervising. You tell me.
SDPO, but an affidavit is filed with the SDPO, Burla.
The SP has to supervise. That's all. SP has to supervise. Otherwise, what best can be done is I can give a direction for
The SP may supervise.
SP should supervise or crime branch has to investigate. SP will supervise. SP.
Your Lordship, would be better if Your Lordship thinks it fit that this case to can go to crime society also. That can be honored.
No.
Your Lordship.
The SP for the which police district. Madam, the petitioner is you are the informant, huh?
Yes, Your Lordship.
Petitioner who is informant in the FIR number so and so has filed the present case seeking what are you seeking? Seeking transfer of the investigation to transfer of investigation to either CBI or CID bracket SIT. The counsel for the state submits that investigation is it preliminary charge sheet has been filed. Huh?
Investigation
The investigation is at an advanced stage. And have you filed the preliminary charge sheet or not? Advanced stage, and the charge sheet will be filed shortly. Regarding head to the contention raised by both the side, time of the condition review that the superintendent of police should supervise the investigation and investigation and file the charge sheet, the final form. By the possible. Let Mr. Jana file a status report by next week. Keep it after week or two, after 2 weeks. Superintendent has to supervise and file the charge sheet. And final form? Yes, yes, final form. Final. And
Oblige, Lordship.
The petitioner shall supply a additional copy of the entire paper book and the copy of petition, counter affidavit, and the result affidavit shall be placed before the superintendent of police within this week. Entire pleading of this court, this proceeding, you place it before the.
You have 3 copies.
Yes.
Oblige.
May I please lose? I pray mana kindly permit to withdraw, man.
Withdraw. Yes.
The petitioner has prayed for quashing of the FIR, which has been registered on the allegations of, firstly, the petitioner having failed to deposit royalty and other dues of 58,70,530, and secondly, of having indulged in illegal mining. Now, so far as the deposit of royalty is concerned, your Lordship may kindly look at the memo I have filed on 25/11/2024.
You
I have filed a memo enforcing certain documents.
Yes.
Your Lordship may kindly look at the document number 2. That is.
Annexure 4 series, huh?
Yes.
Yes.
No, my letter addressed to with the memo, my lords. Annexure 4 series, my lords, is with the.
No, the copy of petitioner's letter depositing the royalty.
Yes.
You have deposited the royalty and inform it.
Yes, my lords.
Yes.
That is by letter dated 28/6/2023. DD for 58,70,538 was
You
deposited.
do it. Yes.
So far as the illegal mining is concerned, I rely on Annexure 2, that is the clarification which the mining consultant of SJTA has given to the SJTA itself, saying that I am not responsible for the excavations made before execution of lease.
Yes.
Page 17.
17.
Yes, 17.
This is going to notice the government.
Now, this was a typed copy which I have filed, a legible copy, to which objection was raised by the state that whether it was original or not. So, along with my memo, I have filed the copy which I have received.
Yes.
Containing his signature.
Which my running senior is relying my letter, that copy is not going to find.
File ରେ ଥାଉ ନଥାଉ ଆପଣଙ୍କର ତ
Instruction ଆଣିଛୁ ଆପଣ ସେଠି ମାନେ ସେ ଜିନିଷ ଆପଣ ଯାଇସି ଲେଖିଛନ୍ତି ଯେ nothing is available in the.
ସେ କେବେ ଲେଖିଛନ୍ତି ଆଜ୍ଞା 30/11 ଲେଖିଛନ୍ତି ଆଜି ଜାନୁଆରୀ ହେଲାଣି କଣ ଏପର୍ଯ୍ୟନ୍ତ ସେ ଏଟାକୁ ଏକ୍ସାମିନ କରିପାରୁନାହାନ୍ତି. It's a simple thing of examining that gentleman and finding out whether he has written that opinion or.
Investigation is going on.
Yes.
Do it and finish it up. See, there are 2 issues. One is illegal mining. And the complaint given by some Chandrabhan, what is his name?
No. He has simply clarified that there is.
No. Chandrabhushan Das. Chandrabhushan Das, he himself gives a letter. And you are relying upon Chandrabhushan Das, this thing, and conclude it. And insofar as the royalty is concerned, he has filed the receipt. It was informed.
ମୁଁ ମେମୋର ଉପରେ ଗୋଟେ କପି ଦେଇଛି ଆଜ୍ଞା ଡକ୍ୟୁମେଣ୍ଟର ମେମୋ ସହିତ ଆପଣ ହଜେଇବେ ସବୁ ମୁଁ କଣ କରିବି
By way of last and final opportunity, 2 weeks time is granted to the state council to obtain status of the investigation.
Status of the investigation I got my lord.
Then,
The 11 in the month of April.
then what do you want now?
I want that my lord senior is relying on document my lord, that is stated.
File reply.
Let him solve copy so that I will give that. Yeah.
Reply and it is made clear that no further adjournment and any pretext shall be granted to the state council. See, earlier somebody else was arguing. Now now you have taken it. So that's the reason I'm giving one opportunity.
Lordship say copy taken.
ଆଜ୍ଞା ଦେବି କହିଲି ଆପଣଙ୍କୁ ସ୍ପେସିଫିକାଲି ଦେବି ପୁରା କପି କରିଦେଇକି ସେଗୁଡା
Give the entire copy, otherwise again.
No, I have to serve it personally because what I serve in the office.
Personally only. Office then it will go. Personal. Yes.
Item 6, I pray for adjournment because I have prayed for quashing of the proceeding. And both parties to appear. They hails from long distance. Kept into Peter on 20th minute.
No. What are you seeking? Let us see.
See the charge sheet
Do
page
you have
13.
anything?
Page 13 is the charge sheet. 417, 493, 376, 506.
Then what do you want?
That
On merit or
pay for quashing of the proceeding. The lady also so much appeared and he also filed an affidavit.
you bring him whenever.
Yes, it may paid for 20th minute.
20th may not be possible.
No, because it was list first week.
24th.
Yeah, 24th minute. As you also.
No, not 24, 28 or 29.
28. As you also.
Yes, 20. Yes. Or bring them.
Yes, yes, ma'am.
Yes.
Well, in this case, yes, yes, counter case, matter already compromising both parties, infant, accused, infant.
Compromise.
Well, affidavit,
Call the parties.
called it, but
Where is the cross case?
Process filed is not filed.
You have not filed. Filed another petition challenging that for quashing of the cross case also. Call all the parties, both the matters can be over.
Case is 307 injury report on Senate.
Yes. Because 3030, no, it's not 307, 323 only. That's it filed, huh?
charge sheet already filed.
Okay. 307. What is the, show me the injury report. Do you have the injury report with you? What kind of injury?
Because of the injury in the head, by means of the.
He fell down on the ground.
Both the border matter.
Compromise होगा case की तरफ आना, both side tackle
Next step,
Urgent कर दीजिए.
matter local.
No, local adalat can't do it. 307 low, how
Take.
local adalat?
Okay.
Yes.
Very please, your lordship. The petitioner has filed this application for quashing of the proceeding. The allegation against the petitioner are silly allegations. Because of the cutting of the Chakunda tree, both are the agnatic brothers. Civil suit is pending, partition. There was a push and pull between the parties and compromise taken place between the parties by the interference of the local defense.
Where are they?
Lordship,
Where are they? Call them. Call the petitioner, call the opposite party.
may I suggest one thing, your lordship, if your lordship will send this matter to the mediation center, I think it will be fruitful and the report will be transferred from the mediation.
No, just see what are the offenses.
Offenses, your lordship,
There are two cases.
lordship, case and counter case.
Then you have to file the other petition also.
Other,
In one petition, both the cases cannot be quashed.
lordship,
So you file another petition.
another, how can I file another petition? So they have to file. If your lordship issue the notice to the other party, other side.
You can also file. You are a complainant in that case.
Yes.
You simply say that we have arrived at a settlement. I filed this petition and
Lordship,
This may also be quashed.
Lordship, matter has been compromised and compromise petition is.
That's right, I understand it, but
Lordship,
you file another petition,
Yeah.
bring all of them, I'll quash it here. Shall I put it on 28th, 29th?
Lordship.
28th, 29th, 29th, and file another petition
Another.
challenging the other FIR, and both the petitions will be listed on 29th. Okay?
Lordship.
And bring all of them, I'll quash it.
If possible. Otherwise, the both advocate will be there. And,
No. The accused persons has to be there.
no, your Lordship, one thing I may be permitted to submit. If they will come and file their affidavit by swearing the affidavit.
No. They have to be here. They are not VIPs. They have to be here. That's for sure. And if somebody is very senior, he can't come and all, you can move an application for exemption.
Exactly.
of personal.
They are very senior. Your Lordship,
And whoever it is senior, just 65,
Your Lordship,
60, 65 is not
yes.
very senior. They can come. 52, what is this? They can come. Yes, they can come. You first file the petition, 29. Yes.
29.
You file the other petition, huh?
Lordship.
Yes.
Item 10 is compromise matter. Parties are coming.
Then do at 12 o'clock. 12 o'clock.
Seven is mentioned, but in the, there is no injury report.
Yes. Bring the injury report.
In fact, the 307 charge sheet submitted.
Yes.
Initially, there was.
That's right,
307
but
was not there.
let us see.
Both the parties are here.
Maybe let us see what are the injuries. Injuries appearing.
Yes.
Injuries also.
Yes.
But let us see the injury report if you have. Try, I'm passing it over. Just yes.
Yes, I do have the injury.
Yes.
Item 11.
The paying for costing of the proceeding, the matter relates to the year 2009. Allegation is that my lord, this petitioner has sold his vehicle to wife of the in the year 2009. Thereafter, my lord, if challenged that at the time of selling of the vehicle, he has obtained a false NOC from the bank. Therefore, he has sold to the. So when the FIR was registered on, you'll also kindly see page 18. On date.
What is the stage by the way? 249.
I'm going to
yes.
14/10/2009. My lord, subsequently, in the meantime, my lord, the wife of the petitioner, wife of the informant has sold to the vehicle on page 29.
She also sold someone. Yes.
On 22/5 now. So where I have committed offence.
You want to get rid of the vehicle by procuring the
no, that
paper.
is not the judiciary.
She might have told, but that will not wash away your offence.
No. My lord, in this case, he has sold. There is no loan outstanding.
And eventually, the person who has purchased, both of you have cheated them.
No. That Suchitra Das has sold, and in the meantime, informant has already been expired. He has been expired. Everything has both.
By the way, why don't you bring the informant? Where is the informant?
The informant is expired in the meantime. What is the fate of the 2009 allegation?
What will you do? What will you do?
2009, this was after. And time and again approach for this court and different bail applications or court not inclined to enlarge the person of bail.
Rejected.
No, he has been released on bail.
But however, in anticipated application, the petitioner was granted bail. Whether now he is released on bail or that order has been carried out by the order presentation or that not been known to me. And so far, litigation is also.
What about the husband of the informant? He has also died.
No, he has been expired. Husband, wife of the informant has purchased. The informant has already been expired. He is a noted criminal as having the 14 number of cases in this thing. Eight type of
But you have 14 cases.
No, you are an informant. 40 cases. He is an informant. He has been expired. But the fate of the case, already there are CF out of गाड़ी पर कौन सा लोन भी नहीं
गाड़ी कौन को गाड़ी
तो इनोवा से ऑलरेडी से गाड़ियों रे कौन सी लोन भी पेंडिंग नहीं आज पर्यंत
So let us see. There is nothing, it's small case.
Infanta Morigol,
I'm issuing notice that we get information.
if the lordship want, I will implement the improper, he has been expired.
No, he has expired.
You record my statement.
The wife of the informant is there.
Yeah.
Implead her.
Yes, yes.
It is purchased in her name.
Then she had already sold the kind of property.
That's right, but that fact has to be verified. Because you are making an allegation that wife has also sold it.
It is Susan that have already sold the
Okay, let it counsel for the
loan be nahi.
seeks leave of this court to implead the informant, implead
She has filed another 482.
in whose name the vehicle was purchased by the informant. Let him do so within a week. Issue notice to the newly implemented opposite party. Demand to accept notice for the state.
The wife of the
What is the stage now?
Yeah, already say yes, stage cognizance roichi. Some of the bail सब अछंदी. That is no किछि ये नहीं.
Some of them, how many accused?
2 accused person.
And who is the other accused?
That is a chief say 485 she tar stay
Where is that?
That is 1816 of 2015.
Release the matter along with are you sure that this number is
Sir, I will verify. From what she has filed 482. That is
because the co-accused petition has to be tagged with this.
Yes, sir. My record, the kind of record my submission is she has filed of 142.
Council
I'm not sure
further
number.
submits that the co-accused has also approved this court by filing a petition under section
Any
4.
notice has been
CrPC. Notice has already been issued in the said matter. Release the present matter along with the CRLFG number.
Sir, I'm not sure. 1816 of 2020.
Check it up, otherwise.
Yes, sir.
Check it up and tell her. Take it. Okay. Check it. How much time it takes? Within a second in a mobile, you can check it up.
1816.
You want me to do all this thing?
No, Nine said that I have not.
2
no.
seconds it takes. 2 seconds.
Yes.
Do it and give it.
Yes.
Right now. Okay. Yes.
Item 12. Please, Lord. This petition related to release of the vehicle implicated in NDPS Act, Lord. And Lordship also considered one this type of that is yesterday item 15. And
how many cases you have? Same cases.
Tin chatta ochita. Tin chatta. How na?
There is a case of the learning the exam is passed the order also. Even assuming that order is in failure. Without preferring the appeal to the state input approve this for it.
No scope, Lord. They have not entertained my petition. If they have entertained, then I.
Let me complete.
Let him take. He has a right to.
Involved in NDPS Act also. The 457 petition approved by the present petition for learning exam without approving the learning teaching assembly also. Even assuming the learning exam passed that order, that against that order, the order is an appeal able to the learning decision is a central option, mechanical option, but without doing so, can be allowed to put an appeal for it to application. And the order which is relied.
Yesterday only I allowed one. The trial court only says that since the application is not mooted through the investigating agency, so therefore 457 doesn't lie. This is wrong, completely wrong. And the recent judgment, I told you to get that judgment, Supreme Court judgment. Where is that?
Paragraph 20.
Where is that judgment?
Yes, Lord. It is. And this is also quoted in page 20.
I am talking about the Supreme Court judgment. I told you yesterday. I had to write like that.
Oh, Lord, just now I'm supplying, Lord.
Otherwise, I'll dismiss it.
No, Lord, just now I'm supplying.
I allowed one petition. See the paragraph which I have written. You want
just
research to be done by me.
No, Lord, I am giving. Just now I am giving, Lord. Within 5 minutes, I will.
See, I had to write.
Yes, Lord. Last
I had to write.
Last lecture.
I had to write para 5 just see.
Yes,
because of you. Without research, without doing anything. The Honorable Supreme Court in the recent judgment.
Yes, my Lord.
I told you, give me the citation. I had to write recent judgment. This much you don't do.
No,
within 15 minutes you don't give, I'll dismiss with cost.
Yes, my Lord.
You promised me to give the citation, you didn't give. While dictating the judgment, I have to search. These people do. You don't do homework and come. 12 o'clock I'll take. Mr. Padi, 12 o'clock I'll take up. If you don't come with that citation, I'll dismiss with cause.
Within 15 minutes.
I don't know. 12 o'clock I'm giving. 15. You have a lot of time. Lot of time. Half an hour extra.
Division bench to refer it so far as this point is concerned. Division bench is, I think, delivered a judgment day before yesterday or something.
See, if there is no answer, what to do? These people should do, young people, they should come with all judgment and all. They don't do. Yes.
13.
13.
Conviction under section 7 of the PC Act mirrors the appel
Sentence?
3 months. Sorry, 3 years. 5,000.
There is no police. With all kind of and all.
Am I audible, my lord?
Yes, more horrible than the usual.
Advocate, realization of fine state and call for tears.
He's on court bail, Millers.
Yes. Advocate, yes.
May I pray for a certified copy and another prayer, my lord? Today's supplementary list, last item for hearing. I am not well, my lord. Last item, item 100.
Very fresh. Very fresh.
If you are not well, why you are coming and opposing Mr. Sawantrai?
No, I am not opposing, my lord. It is a regular appeal. It will be admitted automatically and it will be 100, I will not well, my lord.
Yes, I have noted down. Yes.
Yes, my lord. A free copy of this order be granted today.
Yes.
Oblige.
Item 14 may kindly pass over.
Pass over, okay. Yes.
Item 15.
On behalf of Mr. Jena, he
Yes.
questioned me. This is Belgium matter. He was on bail and bail was granted on 21/12/2022.
NBW?
And NBW is 8/4/2024.
500. Yes.
16.
May I please, Your Lords? This is a Belgium matter. Petitioner was released on bail on 2nd August 2016 and NBW was issued on 4th November 2023.
500.
17.
My lord. My lord, NBW issued dated 27/2018.
Here is the case indefinite, your lordship. Petitioner is an absconder, your lordship. That is not,
Yes. Yes. 17.
I am not denied, but please go through the NHO.
Let me understand what.
My lord, under NHO 2, the petitioner's approach through this honorable court, my lord, in appeal number 20775,
Yes.
2017.
Yes.
By taking the order, my lord, the engaged advocate has been died. That is, I have specifically taken in my para 3. Mr. Tusharsan has been died. Accordingly, there is communication gap between the petitioner and
What happened thereafter, you tell me.
Thereafter, my lord, NBW has been issued.
You didn't go and appear, huh?
No.
I don't. Petitioner was admitted to bail on 10/1/2020. However, he could not appear and the court so neither counsel appear on the data. Leading to issuance of yes. 500.
15.
Belgium matter, my lord. Petitioner was released on bail on 19/6/2006 and NBW issued on 5/4/2010.
5/4?
There are dogs. 5 said there are dogs, your lordship.
NBW?
Yes, madam.
This is 88.
1,000. What to do? He was on bail.
Yes, your lordship.
Bail date. Bail date.
Your lordship. May 6 2006.
Okay. Okay. 1,000.
That is page 7 here.
Yes. Next.
19.
The petitioner was granted bail on 22/2024. The NBW was issued 29/7/2024, my lord.
Okay. Wow. 500. Yes.
20.
No date has been mentioned in paragraph 5. We have mentioned the date, but NBW 9/9/2024.
99/24. 500.
21.
May I please?
This is a Belgium matter. The NBW issued on or dated 6th August 2024. He is in bail from 12.
500. Yes.
22. May I please? And the petitioner was released on bail on 4 December 2018, my lord. No steps have been taken at 24/9/2024. Warrant has been issued. My lord.
Yeah. 500 each.
23.
एक 12/2023 order number 3 21/19
Yes.
order 1/12/2023
Yes.
40. 24.
May please, your lordship. The NBW has been issued on 15/4/2024 and released on bail on 1/7/2009.
Okay. 500.
55. My lord, NBW issued on 21/11/2024, my lord.
24.
2024.
Bail.
21/11/24.
Bail.
Bail.
Paragraph 3 here mentioned that bail was released, but no bail.
Date. You have the date.
No, lords. Okay.
Bail or withdrawal. Yes, next.
26.
My lord, Belgium matter, the petitioner had released on bail on 23/3/21 by this on number 4, my lord. The NBW has been issued on 23/3/21. NBW 26/3/2021. One third.
27.
My lord, the petitioner was released on bail on 12/8/2024. This is the bail jump matter, and non-bailable warrant was issued on 18/9/2024. My lord,
500 each.
Is paid.
highly obliged, my lord.
The Belgium matter, my lord, NBW issued 2/11/2022 and the petition is a religion bail 18/2/2012, my lord. Paragraph 5 I have mentioned.
500.
29.
May I please, my lord? Petitioners were released on bail on 29/3/2016, my lord.
16.
Yes, my lord.
Okay.
Due to non-appearance, my lord, NBW has been issued on 24/11/2021.
21. Okay. 140.
30.
Yes, 500 each. 500 each. 140.
May I please, the lordship? My lord, proceeding under section 138 of NI Act, petitioner represented through a lawyer under section 205 CrPC due to non-taking of steps for a day on 20/4/2024 NBW was issued.
Petitioner is accused in the complaint in ICC case number 920 of 2023. He had moved application on 205 for CrPC, which has been turned down by the trial court and the NW. 500.
Okay.
31.
That one released on bail 19/3/2003 and enrolled has been issued on 11/4/2022.
24. Okay. 500.
32.
No, please. It's a Belgium matter.
This honorable court passed bail on 21/7/2023, but on 10th December 2024 on single date, step has not been taken. Therefore, in issue.
500.
Lordship, may pardon me. Here I am for the informant, I have appeared. Only I have nothing to say, your lordship's order. But he is dragging the matter, it's a matrimonial proceedings are pending and husband's affair, the case has been registered. So maybe completed within a time, 5 witnesses are already examined. She is dragging.
I don't know this petition, there is nothing.
My lord, I have.
You file a separate petition. In his petition, you want to.
Lordship has granted me that leave.
You have a leave. Who stopped you? In his petition, you can't get relief.
On my allegation. It's a tampering of other.
What I can do is I can instead of making 31st of January, in this case, make it 25th January. You appear on or before 25th of January. You can't drag it.
Shall be expedited.
Yes, Lordship.
I don't have any papers. How can I?
This is matter.
I know my limitation, but
You file a separate
you can
petition.
always order before my lord.
And that's right. You are right. Absolutely welcome. But you please file separate petition so that I can. At
This
least
matter-
I should know how many witnesses are there and all.
I have a
Husband,
instruction with me, the order sheet is with me.
File a separate petition. Yeah. And 500 each, huh? To be paid to the informant.
the petitioner is the government servant. Okay.
Whatever you pay the cost to the informant. 1,000 each, 1,000 each to be paid to the informant before the trial. You pay the cost.
Your
to the
Lord, this is a
informant.
matter.
Yes.
Husband file against the wife, my lord.
Whatever you pay the cost, how much you can? 1,000 rupees you can't pay. You don't go and appear. NBW.
Your Lord,
Pay,
I appear in this.
pay to the informant.
Your Lord.
Yes.
Okay.
1,000 each. Huh?
Belgium matter, bail is 27/7/2016. And warrant my lord 11/3/2019. Page 8 and 9.
2019.
My lord.
Okay. 1,000.
34.
1,000 to be paid to the victim before trial. Yes.
May I please? Wife filed a 1cc case number 133/2017, and as per that 1cc case, Law and Magistrate issue a NBW stateway against the petitioner. After the 3 years of the marital, there is a child. After it, there has been a collusion created between the wife and husband. So the case is based upon the quarrel of the wife and husband. And
What do you want?
Let's say quashment of NBW.
So why are you saying so much? You tell me when you are on bail.
Yes.
You are in bail in this matter.
I beg to pardon.
Bail has been granted to you.
41A and
41 NBW issue on 20. 20. 1,000. Yes.
55.
Oblige.
Welcome matter, my lord. Lordship kindly see page 11. NBW issued on dated 22/8/2022.
Yes. How many of you are there?
Two.
You are on bail, both of you.
No.
Dates, tell me.
Date of release is not mentioned.
Huh?
Date of release is not mentioned.
Do you have these dates? Total 11-page petition, including annexure and everything. You are reading here. I'll do it. Thank you. 500 each. I'll do myself. Okay.
36.
I will give the order, my lord.
36. Item 36, NBW was issued on 18/11/21. The bail was on 26/1/20.
Okay. 24. No? 500 each.
37.
21
NBW was on
1,000.
NBW was on 26/9/24. Bail has not been mentioned.
Yes. 24, huh? 500 each. Yes.
38. NBW was on 11/12/19. Bail was on 4/8/19.
4/8?
14.
Okay. 1,000.
39.
Let's see, enrolled dated 21/2015. And they were in bail 8/2008. Lordship.
2015.
Lordship.
Okay.
Only page 12, Lordship.
How many of you are there? 1,000.
Lordship, जीआर केस नंबर बोले गोटे जीआर केस नंबर बोले 530 होगा तो 538 का
जीआर केस नंबर तो जीआर केस नंबर
530 530 बाप दे द साइड नंबर
yes
40. Item of 40 or NBW was 11/24. Bail has not been mentioned.
Bail not mentioned. Okay. 500.
41.
My please, your lordship. And will be issued on 10/12/2024, case 5, ma'am.
Yes.
And he was released on bail on 16/7/2022,
24.
case 4.
500, huh? 31st. 31st, yes. Yes.
May I please, your lordship? NBW issued on 22/3/2024, madam. Bail on Annexure 1, page 7, 13/3/12, 2012, madam. Bail.
500.
Problem.
43.
43, release on bail on 16/3/2007, page 9, and NBW has been issued on 23/4/2011, below,
Huh?
page 11.
2000?
23/4/2011.
11.
Madam.
1000.
44.
May I please, my lord? Same order will be passed this honorable court. Same putting, same year.
NBW was issued on 18/12/2024 and anticipatory bail was allowed
And same order be passed.
18/12/2024.
Same accused.
My lord?
Accused?
Accused Salman Khan, Olga, or another accused.
Accused is different.
Same footing.
Same footing, it's all right. FIR and everything is same.
Same.
कर दो यार, नाम चेंज कर दो, ठीक है? Same order, FIR number change, FIR number.
Space case सब
everything.
Everything same.
25th or 31st कर दो, ठीक है? अब 1000.
Obliged.
Item 3800, I was just trusting.
It's allowed already.
37 of.
Everything is allowed, don't worry.
We both are in a same case, in the same court.
Therefore, the same order I passed. Yeah.
45.
May I please, your lordship? This is a Belgium matter, my lord. On 24/7/23, the date of granting of bail, my lord. And with date of issue of the NBW, my lord, 10/7/24, my lord.
10/7/2024.
2022.
24, my
24.
lordship.
Okay, 500 each.
Obliged, my lord.
46.
I don't know. 36 Belgium Metro.
Already done, sir. In your absence, I have done it. Don't worry.
Belgium Metal Lordship. NBW was issued on 25/9/2024 and bail was on 24/2000.
2000.
Yes.
Okay. 24 is the rate, huh? 500.
47.
In this case, the petition under section 205 was allowed on 15 March 2021 and NBW was issued on 29 February 2022.
Okay.
How's it going, Lale?
29/2/2024.
3/21. 205 allowed. And NBW issued on 29/2/2024.
24, 500.
8.
Petitioner was bail 12/10/22. NBW issued 13/9/2024.
500.
49.
49, my lordship, there are two petitioners. And petitioner number 1, bail was granted on 17/2/2014. And petitioner number 2, bail was granted on 27/11/2013. NBW was issued on 14/8/2022 for both the petitioners.
22, 500.
50.
May I please, Lord, the petitioner was released on bail on 9th November 2020, and he was
2020.
no,
Okay.
9/11/2020,
Yes.
and NBW was issued against him on 4th May 2024.
500.
51.
NBW was issued on 5/4/2022, and the bail was granted on 22/2/2012.
500. Okay.
Yes.
52.
May I please, Lord? First to last of the lordship directed to produce the state deposition copy of the informant lordship.
Yes.
So witness has been already and all the witnesses have already been declared lordship. The vital witnesses lordship. So informant statement lordship deposition copy have submitted lordship.
And he also not support to prosecution story Lordship. And the petition is controlled Lordship. 24/9/2022 and charge sheet has been submitted on 2023 and last Lordship 2.5 years in judicial custody Lordship. And all the vital witnesses have already been examined. They have not support to prosecution story Lordship.
Yes. Yeah.
Another witness is there, my lord. Is Pankajini Rao.
So, now what is the case? You first tell me.
Case is my lord. Shankara Naik this petition. Shankara Naik so तार स्त्री साबित में मदर की पैटर्न तो हुई मो दुकान फैसले तापर गोविंद राव
Yes, yes, Mr. Jana, what do you say?
Only except for all others are not supported.
Then
Company to be exact.
what is the role? Has he
Stereotype. They said the.
No, Pankajini, who is Pankajini?
She stated that she was taken to that house. Thereafter, only the one that would.
Oh, that's neither here nor nobody is seen. Nobody is right of petition rejection. The vital witnesses, Govind Rao, bracket PW1, Tirlochan Bainipati, PW9, and Ashok Rao, PW8, has already been examined, apart from the offensive witnesses. The three witnesses, those who have been cited as the vital witnesses by the prosecution, have not supported the prosecution. All of them had been, all of them had declared hostile. No, that's not supported the prosecution. The PW9 the cross exam in his examination, CP stated whereas the other two witnesses, that is PW1, in his statement has stated one.
One hospitals.
Whereas the PW1 example, PW1 to para 1 below, para 1 to PW0 para 2 liquid. PW1 has been declared hostile by the prosecution and subjected to elaborate procedure. However, nothing could be elicited from his statement. Petitioner is in custody since 24/9/2022. How many witnesses are there?
70.
70. Total witness exam 9. There are total there are 70 witnesses cited by the prosecution, out of 9 witnesses have been examined. Petitioner is already in the custody for more than 2 years. More than 2 years. None of the vital witnesses is supported with the prosecution case. The trial is likely to take considerable time. Therefore, I am inclined to not it's not being granted. Yes.
Yes. Maybe pardon. In item number 49, I was in coming from old building.
It's allowed.
Allowed. I'll not press for petitioner number 2. Petitioner number 1 for 1, I'll press only. Because he has already been released.
49, 49.
Petitioner number.
The Constable petition submits that you not press this petition insofar as petition number 2 is concerned. The petition number 1, you will.
Bail is 17/2/2014 and NBW is 14/8/2023.
Okay. Henceforth, never ever
No, man.
mention in between.
I'm a partner.
Wait till the court resumes. Okay. Yes.
53, my lord. Process may kindly see the rejection order, page 9.
Page 9.
302 is the offense, my lord. Investigation it is not, many things are yet to be unearthed. So investigation at this time of investigation is moved, let them try after the charge sheet, they may move 302
Right
is the
on.
offense.
Petitioner is accused. How this matter has come to me?
I don't know.
Why this matter has come?
One application, your lordship has in dispatch of 4548, your lordship.
Same accused.
Other accused, your lordship.
Other accused.
Other accused, your lordship. Bail appeal number 4548 of 2024, your lordship.
Charge sheet is
already submitted, your
But
lordship.
the rejection order, your lordships, I have shown your lordships.
No, but charge sheet has already been filed. 26/7/2024.
No, I am saying that because before the charge sheet they have moved. And the rejection order shows.
When the rejection?
Rejection is, my lord, 29/7/2024.
Then this order may be wrong. It says that on 26/7/2024 it is filed. Charge sheet has been filed.
But your lordship's page.
When the charge sheet is filed?
Page 9 of the rejection order, lordships last.
Have you prepared it? Have you read it or you are trying to read it here? When the date of charge sheet, you tell me.
Your lordship, your lordship 8432 is filed after charge sheet release. Other three bail applications
After 2 weeks. You can't read it here. After 2 weeks. Yes, next 54.
I permitted to submit on behalf of Mr. Panda, my lord.
Yes.
This case, my lord. The petition in custody since 9/5/2024.
9/5/24,
madam. Charge sheet submitted 3/9/24.
24.
Offense under section 420, 408, 467, 468, 471.
Yes.
120B for IPC. With regard to 120B IPC, there is no such conspiracy, no except this petition charge sheet submitted only against this petitioner, my lord. And with regards to, my lord, the financial transaction, my lord, they have stated that a misappropriation of total amount 2,63,900, 9,860.
Yes.
This petitioner working as a accountant in the office of the petitioner, my lord, the informant, my lord. Informant having a company named Mrs. This C Court Construction Builder. In fact, he is a builder, my lord. Subsequently, he stated that he is a company. Though the petitioner quit the service from 2018, my lord. They waited till 2020.
He cheated many people, you cheated him. That's the story.
I have
a builder, he cheated many people.
Exactly, my lord.
And you cheated him.
My lord, in the meantime, what happened, my lord? He has stated that from the year 2015 to 17, he quit the service on 18, my lord. He has misstated 2 crores and some more, my lord.
How much? What are the amount transferred to your account?
My account, my lord, 2 checks, my lord. Checks, my lord. That is
18,27,500.
You deposited that?
No, my lord. What my instruction is that, my lord, 2 self checks, my lord. One is 1,20,000, another is 1 lakh.
No, transfer from the company account to your account.
My account, my lord, they have, my lord, filed the informant file affidavit. They have stated that, my lord, the charge sheet submitted 2 crores, my lord, misappropriation. But the informant file an affidavit stated that 4 crores, my lord.
That's a different story. I'm only asking one question. What is the amount transferred from the company account to your account?
I have given a chart camera glass below. I have filed on.
Although it is not a recovery proceeding.
I am filed on 13/1/25 camera glass.
I will go by IO's. Seal code, huh?
Seal code.
Seal code to your account. This is his account.
After withdrawing the all
What
the
was
amount,
your salary? What was your
14,000 only, my lord.
14,000.
My lord.
Then why the company from company
I am
transferred to 80,000, 56,000?
Exactly, my lord.
1,20,000.
But that is after withdrawing from my account, I withdrawn this, my lord. Payment the workers and others, my lord. Since I am the accountant, my lord, dealing with all the matters, my lord.
What is this? You will transfer from company account to your account, then you withdraw and give it.
No. Some cases, my lord. Some cases, whenever the director
you deposit. Whatever money you have taken from the company, you deposit, I'll grant you bail. In any case, bail is to be granted, not that.
My lord, she costed 9 months, my lord. 14,000 salary. The lordship in a 3 to 4 lakhs, my lord, depends, my lord, then religion.
Why 18 lakhs you transfer?
Subsequently, my lord, that will be after release, my lord, will arrange the money. 9 months in custody.
Only my submission may recorded that I have filed an application affidavit indicating that he has withdrawn 4 crores from odd million to his account and others account. Can the glass 13-1?
But the investigation says only 18 lakhs.
Still open, my lord. But can it 13-1?
13? Page 13?
But I filed that application, that affidavit, my lord.
Affidavit, okay.
That affidavit.
Yes, page 13?
That affidavit.
Yes.
Affidavit dated 13-1.
Yes, I'm there.
I have annexed, my lord, 2 enclosures.
A2 you have had.
2 enclosures, my lord.
Yes.
Number 1 enclosure, my lord. Money transferred, my lord. Money withdrawal from the company account by the petitioner and transferred to the other account. That is there.
Other account, construction company account.
Who are they? SK Das, Abhay Kumar Bari, Saroj Kumar Manti.
Fake withdrawal, title likha hai.
Fake.
And then enclosure 2 minute kind of a glass. Money debited from the company account and credited to account of Saroj Kumar.
It comes to how much?
Total like 4 koti something.
No, in his account.
His account like aschi 2 lakh 2 crore 35 lakh around 20 lakh minus करते लगे तब लिखा है कि already mentioned माने या previously mentioned है कि सेटा 20 lakh minus 2 crore some order होती
है entire transaction से देख लो जमा करे entire transaction.
Yeah, have you checked up this? He has filed this accounts. You say 18 lakhs, he says some crore.
But the charge sheet, my lord, I will file somebody charge sheet.
What I'll do is
true course 6-7
give a copy, let him verify, and meantime you tell me how much you deposit. It is not a recovery proceeding.
My instruction, 9 months in custody. My instruction that he has only, my lord, received self check 2 lakhs, my lord. That much, my lord. Other than what they have stated, my lord, the balance sheet.
Investigating agency found the bank statement is there.
There was an audit, my lord. The audit is there, my lord. Income taxes, they are payment there, my lord. Also, my lord, they have balance sheet, submitted balance sheet before the ROC, my lord. Everything they are okay, my lord, in 2018, my lord.
I'll tell you why. I'll tell you, he might be the builder.
My lord.
Cash must be received. You are the handler.
My lord. I am a handleman. That is
you have been handling. Both of you know each other very well.
Petitioner came to know that the director not doing properly. For that he resigned from the service 2018.
Dismissed from the service.
Anyway, you come with the instruction.
I'll put next week. The report 3 lakhs initially, then after release, he purchased.
Talking about crores, you are talking about lakhs.
No, crores, he has not specified crores, that is not correct, crores,
verify, you verify, just let us verify, and I put it on 21st. 21st. Huh? 21st.
18.
18th of? No. 18th. January 21st.
20th
or 21st? 21st.
Because he has to examine the
he has given a very detailed date and everything is given. You have to go and sit and check.
What he has given, my lord, that is not in the charge sheet, my lord.
So I just want to verify.
I just want to take time, my lord. Your lordship may fix it.
27.
22nd.
Bail matter, he has
22nd.
22nd.
Okay.
55.
And give some respectful amount to him at least.
But what they have stated, that is not correct, my lord. Entire transaction, my lord, 5 years, my lord, to 4 crores to transaction. They have cheated many people, my lord. The company. And
therefore, you don't have a right to cheat him.
No,
because he has cheated someone.
My lord, only 2 lakhs something he has taken, my lord.
Just check how much you can pay. Yes.
55 items, it will kindly take no one look at.
That's yes.
7.
57. May I please, Lord?
57.
Please, Lord. Here, my lord, initially the case was registered under section 307, my lord. Thereafter, subsequently during treatment, he succumbed to the injury. That is why 302 was added.
Custody since?
Custody since Lordship, January 4/1/24.
Yes.
And your Lordship, this is the second round. During pendency of the bail application, your Lordship, charge sheet has been filed. Thereafter, your Lordship has directed me to move to the court below, ventilating all the grievances thereafter. And now, after filing before the court below, I have again approached your Lordship.
Yes, sir.
And the prosecution story is, my lord, the petitioner is the conductor, boss conductor, my lord. The boss was flying from Cuttack to Bhubaneswar, my lord. And in that bus, the injured was died, my lord, subsequently. He was a passenger without ticket, my lord. So he asked the ticket, then he did not give the money. He said that I don't have any money, I will not pay. Thereafter, there are some tussle as per allegation, my lord. And the allegation is that he pushed the person, he fell down. Thereafter, the running bus ran away over on his leg, my lord. Then
he fell down.
Fell down.
Okay.
Then after 27 days under treatment in SC Medical College, he succumbed to the injury on 29th of February. Thereafter, charge sheet was filed, my lord, alleging 302. So I am in custody since January 24 and only earning member of the family.
Eyewitness.
This is the statement I am placing.
Where is that?
This is Pradipta Kumar Raut man. କଟକରୁ ଭୁବନେଶ୍ୱର ଦିଗର ବସ ରେ ମୁଁ ଯାଉଥିଲି, ମୁଁ ଲିଙ୍କ ରୋଡ ଚଢିଲି, ମତେ କଣ୍ଡକ୍ଟର ଟଙ୍କା ମାଗିବାରୁ ମୋ ପାଖରେ ପଇସା ନଥିଲା, ତେଣୁ ଦେଇପାରିଲି ନାହିଁ। ରାଗି ଯାଇ ମତେ ଗାଳି ମନ୍ଦ କଲା, ଆମ ଭିତରେ ପାଟିତୁଣ୍ଡ ହେଲା। ମୁଁ ପଛ ସିଟରେ ଆଗ ସିଟରେ ବସିଥିଲି, ମତେ ଠେଲି ଠେଲି ସେ ବସ୍ ଗେଟ୍ ପାଖକୁ ଆଣିଲା, ସେଠାରେ ଗାଳି ମନ୍ଦ କରି ବସରେ ଠେଲି ଦେଲା। ସେତେବେଳେ ବସ୍ ପାହାଳ ଇଣ୍ଡିଆନ ପେଟ୍ରୋଲ ପମ୍ପ ପାଖରେ ହୋଇଥିଲା। ମୁଁ ତଳେ ପଡିଯିବାରୁ ମୋ ଉପରେ ଗାଡି ଚଢିଗଲା ଓ ମୋ ଡାହାଣ ଗୋଡ ସମ୍ପୂର୍ଣ୍ଣ ଛିଣ୍ଡି ଯାଇଛି। ମତେ ସେଠାରୁ ଲୋକମାନେ 108 ଆମ୍ବୁଲାନ୍ସରେ ଏସି ମେଡିକାଲକୁ ଆଣିଲେ। Then subsequently.
Any other eyewitness? Eyewitness?
Eyewitness.
Any passenger?
Mamata Raut. I have to verify that postmortem CDS come. Postmortem report have
Not required. It is admitted position because
he succumbed to injury.
Right.
Only he himself stated that he was in bus and
he was pushed from the running bus.
Running bus.
And he fell down, the bus ran over him.
Run over. After 27.
And any eyewitness to the, see the problem with you is that 164, statement of the deceased. Now it will be treated as a dying declaration.
Dying declaration. I do admit, my lord, about intention.
32 of evidence. That's the problem.
That is the problem.
There is a dying declaration.
Yes, my lord, because before that he has stated
and
so.
To support that, do you have any evidence? Eyewitness?
That is Vivek Kumar Rao.
There is no intention, my lord.
Let's check it up from the in the bus. Somebody else.
Suppose treatment is there after he was died.
Yeah, that is admitted.
That those things are admitted.
That is admitted.
Do you have any eyewitness to that? To support land support to your dying declaration? How many days he stayed in the hospital?
27 days.
27 days.
Yes, sir. Second, he admitted 29th.
When the statement recorded?
The statement was recorded on 4/1/2024.
Okay. Just check it up. I'll put it next week. But it would be, see, there is no intention as such. Kill him.
That is whole.
And the driver has stated.
Driver can't state because he was
He was driving, my lord. Only the driver says.
behind his
my lord.
back.
Only the driver
That's
says.
right,
my
but
lord.
driver must be driving. He
Yes.
can't see back.
No. Particularly गाड़ी का
Any
running.
other co-passenger?
No, my lord. Only
There is
driver
no-
statement is yes, he pushed and thereafter he fell down.
Check it and tell me because he is already there about a year or so.
Lots.
Yes. Yes, sir.
For offense under section 302, 201, 149, or 109, the petitioner is in custody since 16/5/2023. Some of the co-accused persons have already been released on bail. So far, the present petitioner, so far as the present petitioner is concerned, my lords, is allegation against him is that statement that he was there along with the other accused person. And if a lawsuit says one order lawsuit had been pleased to pass, that is.
What is the difference between Kalia and this Prakar?
Kalia, if you also look at the order of the Kalia, my lord, paragraph 7.
May I say one thing, lords, tomorrow. I have to clarify.
Just check it up. If there is no difference, much difference, then we will end that. He's already there in custody.
16/5/2023.
23 means about
1 year 8 months.
1 year 8 months.
Also.
Let it be Monday. Tomorrow will be,
Full court reference. Monday.
Monday.
Okay,
I'll just come. This is adjournment. Wait. 12 o'clock.
The information will not come with the notice in solved or not. I should have thought.
Notice is not.
The instruction has not yet come back.
Okay. The notice was directed to be served through the IO of the notice to the informant. Is directed to be served through the IO of the case. However, no information has been received by the State Council. and she seeks an adjournment, release the matter.
What's shorted, man?
Yes.
61.
Today. Mediation.
So mediation is scheduled for.
Okay. Mediation report is awaited. Release the matter.
My lord, my pardon. In this matter, I am for the informant. This is a case and counter. In the present CL.
Mediation is fixed today.
Yes, ma'am.
Go and participate in the mediation.
And one thing, ma'am. I am also filed for its CLNC application for regarding the passing of the FIR, ma'am. My lord, in the next statement, my case also.
Are you going to settle the dispute?
Yes.
Likely
Yes,
to settle us.
Today-
For the informant submit that he has filed a 482 petition for seeking quashing of the cross case. The same petition may be listed with the present one. Leave the matter alone.
Copy may kindly be sir.
Copy give a
Yes, sir. Today I am supplying.
This is 2392. 2392 claim. Okay. ये 2392 corner. Like I know 62 है ना? 61 है ना?
61.
Okay. Yes.
62.
Last occasion, my lord was pleased to adjourn the case.
To file a status of this Supreme Court case.
That is pending.
No, sir, let me file that.
So,
yes,
this of the
yes.
अपना interim also दे देते हैं जहाँ अलग-अलग.
In fact, my lord, in paragraph 7 in my last order, their prayer has been partly allowed.
It is stated that the proceedings pending for the Supreme Court has not yet been disposed of. Awaiting the outcome of the state proceeding, release the matter. Interim order to.
Let an affidavit be filed on about the status.
Yes. Yes.
At the official website, you can see immediately what.
Available.
Yes.
63.
Let's see. The question of this matrimonial dispute. Let's see. In this case, opposite party has been already received permanent alimony and divorce has been allowed. Let's see. Annexure.
What is the service position? Sufficient.
Lordship, can be in order dated 11, 12, and 24, Your Honor.
11, 12 years. Notice on opposite party number 2 is sufficient, but now
One more opportunity is given with the Lordship.
Yes.
Notice sufficient is it 2 times?
Yes. You are seeking quashing, huh?
My lord. Let's see the annexure 4. The judgment of the family court lordship has been already received to permanent alimony.
Right.
Divorce has been already allowed.
And what are the settlement? Is matter contest or settlement?
Mutual divorce.
Mutual.
That page 34, Your Lordship, there's the judgment and decree, Your Lordship.
Right on. Petitioner is the petitioner. One, the petitioner is the petitioner number 1 is the husband, huh?
My lord.
Huh? 1 is husband.
Dhanadhara Mahanten. It's one is husband or not?
Father-in-law lordship.
Who is husband?
Lordship Ramakanta Mahanti.
Petitioner 5.
My lord.
Huh?
My lord.
Are you sure?
My lord.
Yes. The petitioners have invoked the jurisdiction of the court and authority to CrPC seeking quashing of the FIR and consequential proceeding, FIR number so and consequential proceeding arising there. The next problem. The petition number 5 is was the husband of opposite party number 2. Opposite party number 2. The parties have settled their dispute. On the basis of the settlement, the petition number 5 and opposite party number 2 approach the family judge Bhubaneswar by filing CP number 288 of 2018 under section 13B of Hindu Marriage Act for dissolution of their marriage by mutual consent. The family judge Bhubaneswar filed its judgment dated 10/1/2019 and allowed the petition and dissolved the marriage between petitioner number 5 and the opposite party number 2. For opposite party number 2. The opposite party number 2, the petitioner number 5 has also paid permanent alimony of rupees
4 lakhs.
4 lakhs.
4 lakhs. 4 lakhs as permanent alimony, which is reflecting from the judgment dated 10/1/2019 passed by the family court Bhubaneswar in CP number 288 of 2018, which has been placed on record as Annexure 5, Annexure 4. Notice was issued to the opposite party on 3/10/2024 by this court. The notice was duly served on opposite party, awaiting appearance on behalf of her. The matter was adjourned time to time. Eventually, on 11/12/2024, the following order was passed. Today, when the matter was taken up, again, none appeared for opposite party number 2. The counsel for the petitioner submits that the opposite party number 2 is avoiding appearing in the court for the obvious reason that she has already received the permanent alimony and marriage between the petitioner number 5 and opposite party number 2 has already been dissolved. In these circumstances, he submits that the present matter may be taken up for hearing, taken up, and the criminal prosecution initiated by the opposite party number 2 against the petitioners may be quashed. And then the counsel for the Ministry and counsel for the state submit that the dispute is arising out of matrimonial discourse. Parties have already settled their dispute, and pursuant to the settlement, the petitioner number 5 and opposite party number 2 has applied for dissolution of their marriage by mutual consent, which has also been allowed by the family court. Therefore, there is no legal impediment in pursuing the entire proceedings. Regarding to the aforementioned, I'm inclined to allow the present petition, particularly for the reasons that subjecting the petitioners to the rigors of the trial with their time to be a futile exercise. The case of the present petitioners are directly covered by. Where are the petitioners, by the way?
It's personal appearance was not.
I forgot to ask you, where are the petitioners?
The petitioner.
They have to be here.
That was not ordered in the. Let's say.
Why should I order? You have to be here. I have drafted it. Bring them tomorrow.
Well,
bring them tomorrow. I have drafted it.
Well,
I have passed the final order. Okay. The judgment of the report in Gyan Singh. Okay. Kali pe rakh diyo, the order with me, and tomorrow let them appear and one paragraph you write that petitioners are present in the court, present in the court, being represented by their counsel, identified by him, and they have filed the self-attested copy of the Aadhaar card to establish the right. You bring it tomorrow. On video conferencing also one can appear, no problem. See, how many of them are there?
5 persons.
5 of them are there. Okay, at least the husband and who else? All of them can appear. Not very senior. If anybody can't come, move an application for exemption from personal appearance. And tomorrow. Okay, tomorrow. Today only make it for tomorrow, and this order type it out. Yes.
67.
Maybe. The order dated 10/12/24 para 4 minor.
Yes.
Same data है.
Para 4.
Para 4 में.
Yes.
Ground of character if such bail application moved from by the
Both the court
petitioner.
below are considered the same on the basis of the material available. What do you want?
Same day. Same day নহলে হবনি. ঢেঙ্কানাল হিন্দোল ডিফারেন্স 40 কিলোমিটার.
No, this you are seeking modification.
Yes, madam.
And for the reasons stated in the application, the same is allowed. The para 4 of the order dated 10/12/2024 passed by this court is modified. The same shall be replaced by the following paragraph. Therefore, it is open for the petitioner to move application before the court below for grant of bail on all the grounds, including the ground of parity. Full stop. If such application is moved by the petitioner, both the courts below shall consider the same on the same day on the basis of the materials available on record. Okay.
State will till 31/12/2024 थी सीधे.
Sorry?
रूलटा.
The next paragraph. Letter comes for the petitioner further submits that the date for surrendering appearing by the petitioner before the court below may be extended up till 30th of January. Accordingly, the petitioner shall appear public surrender before the court below on or before 31st of January 2025.
68.
May I please, my lord? My lord, on last occasion.
Shall be granted on any ground whatsoever. No further extension shall be. Sorry? Yes, yes.
My lord, on last date, your lordship has directed me on that is on 6/1/25 to implement the informant as opposite party number 2.
Yeah.
And file the requisites in the same course of the day. I have filed the requisites and I have filed an IA to implement the opposite party informant as opposite party number 2. Flag A.
Flag A.
My lord.
The IA number 65 of 2025. For the reasons stated in the application, same is allowed. The informant is allowed to be implemented in the opposite party number 2. Mandatory memo of party will be filed to be waived. Letter comes for the petitioner submits that requisites has already been filed for effecting service on opposite party number 2. The same may be utilized for the service of notice on opposite party number 2. List the matter also. Yes.
My lord, on 28, my lord, may list this matter on 28.
28 notice will go and I don't think.
It will come from Anandapur, my lord, that is.
28. Let it be 30th, huh?
Of last
30th.
And till that date, my lord.
No, last time I am not given. Yes.
Oh.
Yes.
71.
Which one, my lord? Correction of typographical error.
Where? Which order?
Order dated 10 January 2000.
What typographical error?
Paragraph number 3. Stay word as missing.
Stay of?
Stay word as missing. Proceeding in 1CC.
Meanwhile, the further proceeding in so and so pending in the court of so and so or just stay. So what? Further proceeding is stayed, na? Further proceeding what? Stay for the what should be the order dated 10/1/2025, right? Para 3. Further proceeding is stayed. Stayed study. Okay. But it is understood.
72.
Yes, may I please, your lordship? My lord, this honorable tribunal is directed in 38/2013 to regularize the service of the petition.
Now what remained?
My lord, they have not regularized, my lord, my entire service
We have,
period, my lord.
we have
Out of
already
10
complied
station.
pursuant to the order. Your lordship kindly turn to flag P. We have filed the compliance affidavit on 18/12/2024. Flag P.
Yes.
My lord, this matter was listed on
29/10/2024, and they have submitted by the additional government advocate that has been complied, my lord. And my lord is directed to file a compliance affidavit. On 18/12/2024, the matter was again listed, my lord. And they have not filed any compliance affidavit, my lord. And I
Compliance affidavit by way of e-filing.
have you served it? Have you served the
This
copy
is
to me?
This is the, we have filed, e-filed by on 17/12/2024. Copy of the compliance report. I have.
Compliance report, compliance affidavit dated?
Dated 17/12/2024. It is at flag P.
Flag P, yes.
Last
My lord, nowhere they have stated, my lord, in the compliance affidavit, my lord, that they have regularized my service, my lord.
Show me the judgment which was supposed to be.
Yes, my lord. Kindly have a glance to the.
Show me the judgment. Yes.
Yes, my lord. Running page 15 of my contempt petition, my lord.
15.
Yes, my lord.
You made so voluminous. This contempt petition is
No, first
larger than the main
first
petition.
petition.
Yes.
Third, first,
15.
Okay, my lord.
Yes.
Yes, my lord. That is it. 15, my lord.
Yes.
Third, land council, my lord, I will read the operative part, my lord.
Operative, yes.
In the result, the running page 17, my lord. In the result, the OA is allowed. Respondents are directed to regularize the service of the applicant with all consequential service benefits as per the rules, including arrear of salary and other retirement benefits, my lord.
So then arrears of salary, retirement benefit, and
After regularization of
regularization.
My lord, after regularization of service, my lord.
Directed to
There are
regularize
10
service.
stations to be regularized, my lord.
Yes.
Out of 10 stations, my lord, only 7 stations have been regularized. After filing of several complaints, they have filed complaints, it is in compliance.
Now come to the compliance.
My lord, compliance.
That's it.
Where have we, let him to tell, my lord, where they have stated that all the 10 stations have been regularized. Only that one only, my lord. I have also filed an additional affidavit, my lord. Out of 10 stations, 3 stations have not been complied, not been regularized, my lord. In flag Z, my lord. I have mentioned in flag Z.
You got 33 lakhs, 23,23,000.
My lord, that is not the case of the order of this honorable court, my lord. Only order was the regularization of service. If it was regularized, my lord, I am entitled whatever the payment is there. I am entitled to.
How much you are entitled?
Well, only regularized. My case is only regular. Not, I am not disputing. I am only for regular. Where they have stated about regular, I have mentioned in para 3 of my additional affidavit. Kindly have a glance, my lord. That the petitioner humbly submits that, my lord, that is the flag Z, my lord. That the petitioner humbly submits that the entire service period of the petitioner working under different stations were not taken into consideration and made his duty periods as extraordinary leave, debarring him from his qualifying service, causing him heavy financial loss and injury. His earned leaves and half-pay leaves are not taken into account. So far as the casual leaves are concerned, the leave applications submitted by him, them are not considered. And fear of personal appearance. From time to time, the period of his unqualifying service are decreased as follows. My lord, first they have stated that 2,676 days. Thereafter, it was decreased under Annex 18, 1,876. Thereafter, 1,846 days. My lord, but my humbly submission before your lordship that NSC Khoria Road, para 4, I have mentioned along with the documents that I have worked there that have not been regularized.
Previous show cause. Paragraph 10.
Nowhere they have.
It is humbly submitted that with due deference to order of this honorable court, the department have taken all possible steps to trace out the records of service at different stations and taking into account the availability of such record, the service of petitioner have been regularized. And all the arrear salary due to the petitioner have been paid to him in different spells. As reported by the Superintendent Engineer, RWSS Circle Nuapada, letter number so and so.
I have
Our so-called
since last 4 compliance episodes, they have stated the same thing, and all the documents are there, my lord. Those documents are submitted before themselves, my lord. And they are saying that they have tried all the steps, my lord. What steps they have taken?
Physical copy.
My lord, kindly have a glance to my documents, my lord. I have submitted.
I'll pass yours. I'll pass yours. I understood it. Yes.
My lord, so far as flag jet is concerned, that may
Next. I understood. Yes.
73. On 73, on behalf of Mr. Islam, has kindly taken over after 1 week after.
Adjourn on request.
74.
Wait, please, your lord.
Yes.
Here, my lord, the petitioner has challenged the order taking cognizance passed by the land magistrate in taking cognizance of the offences under 120B, 468, 471, by 34 of the Indian Penal Code. The last occasion, my lord, my friend had taken time.
Yes, Mr. Vishal.
Are
you ready?
Squarely covered by.
I have not gone through the volume.
Mr.
My lord friend is there. Well, my lord friend is there. He is prepared.
Why are you changing? She was appearing, now you change.
She was of the opinion.
You don't have a system of holding the brief.
Case squarely covers my lord the judgment of Hon'Ble Justice.
What is the system? What is the system you follow? Let me understand. Last time you appeared.
Yes, ma'am.
And you say that I am prepared. Now how the brief has gone to Mr. Vishal?
He has also opted instruction that is squarely applicable.
Yes, I have seen my lordship that judgment. Justice arbitrary.
Why the brief has changed? What is the system? You must follow it. Because somebody is holding a brief, she should continue or he should continue.
Last time we have filed a memo, and
the problem is the problem many a time what happens is in the order sheet everything may not reflect.
Yes.
But once you appear, you know what transpired in the court.
Yes, ma'am.
The counsel is changed every hearing, then we can't proceed like this.
We have brought to the notice of.
No, where is Mr. Jena? You should follow some system. If somebody is holding a brief, he should continue or she should continue. So that the continuity in the what had transpired in the last proceeding can also be, recalled. Please give the file to her and let her do it. I'll take it up Monday. I'll take it up Monday.
Yes, ma'am.
You people sit together and try to find out a way.
Yes.
This is
75.
The interim order till that.
Interim order to continue.
That till that date.
What password? 75. 76.
Wait, please, your lordship. Here I have challenged the initiation of the proceeding against the petitioners, which is nothing but crops up out of a personal vendetta with the immediate neighbor. But the allegation as alleged for the offences under section 341, 323, 294, 353, 534
yes.
of the Indian Penal Code, the reduced section 30, that is valid by 34, 341, 323, 294, 353 by 34. My lord, petitioner before my lord are father and son, one is a retired professor of OUAT, and the second one, my lord, is an engineer in a multinational company. It is alleged by the informant.
No, the petitioner number 1 and 2 are the
father and son.
And who is the opposite party?
My lord, they are the officials. They say, my lord, we had gone there for measurement, but they didn't allow father and son and wife of petitioner number 1, the retired reader from B.G. Patnaik Institute of Technology.
Yes.
They didn't allow me, allow the informant to measure. The question crops up, and they scolded me there in the campus, and they didn't allow. They obstructed us, for which 341, 294, 353.
Who is appearing for opposite party? Number 2 and 3.
Opposite party
You
one.
have to have applied Bhubaneswar Municipal Corporation.
No.
Then
Niranjan Bainipati.
and Babu Charana Barik.
Who is appearing for them?
I don't know.
Service.
Office of Bhubaneswar Municipal Corporation and
No, service on opposite party number 3 is not complete. Service on opposite party number 3 is not complete. Petitioner is directed to take first step for serving of party number 3. Please the matter also and interim order to continue. Interim order to continue. Yes.
again, my lord, I'd file
The IIC of IO of the presidency is also directed to serve copy of the petition to the opposite party number 2 and 3.
I'll fix up a returnable date on 3rd.
I'm giving a date and give additional copy to them so that.
My lord.
Yes. Fourth. February. Yes. 4th February. Yes. 5th. Okay. Interim order to continue.
78.
Yes, my lord. Where for last 40 years, for non-payment of provident fund dues, the case is lingering. Payment has been made, it's been accepted, and only thing, my lord, for dropping of the proceedings, my lord, because it's only a case of 1,000 rupees or 6 months imprisonment.
On the last
Fine.
on the last appeal, your lordship asked me to submit what amount to be paid.
Affidavit.
I have already filed an affidavit to the effect that no record is available.
No, in the paragraph 9, my lord, in the affidavit, your lordship may see the document given, last line, paragraph 9, the document given in Annex 5 and 6 are admitted to be of answering opposite party. So that means the payment has been made by 5 and 6 is that payment.
Which paragraph you are reading?
Paragraph 9 of their compliance affidavit. Sorry, their affidavit, your lordship, flag P. Flag P.
Yes, I am reading paragraph 9.
Paragraph 9.
Extensive search caused by this so it could not be traced. No legacy data is available in the system, means it cannot be conclusively ascertained whether the petitioner has paid the dues of worker and however. Then how will you prosecute then? How will you prosecute? You don't have a single paper.
This is the problem. If it is paid, then it would be a problem for us to disburse the amount to the.
So what is the roadmap now? Why should, if you don't have a single paper to prosecute,
yes.
So how to proceed about it? It has to be cost, it has to be dropped. Right. Where is the complaint?
Complaint petition, your lordship, Annex 1. Annex 1, page 9. They say, page 10.
Passing of in order dated 20/12/2021. Where is that order?
Madam. Impugn order, my lord.
Passed by S. Cuttack 2 CC number 17 of 1980.
Annex 4.
86, whereby cognizance.
There are two orders, my lord. One with regard to 205, another with regard to dropping of the proceeding. So that is at page relevant page 20. Page 20.
20.
Yes. Hence, in view of the facts occurred at this stage, the accused petitioner cannot be discharged under section 245.
You move application under for discharge.
I moved an application for discharge and also for dropping of the proceeding. So
whereby the application moved by the petitioner for dropping or discharging them from the offences has been turned out. Notice was issued to the opposite parties, namely the Provident Fund Inspector, Provident Fund Department, Provident Fund. Pursuant to the notice, the opposite party number 2 has filed an affidavit dated 18/12/2024. The relevant part of the affidavit reads thus. Para 6. Seven, 8, and 9. The precise ground on which the opposite party opposes the prayer of the petitioner is that there is the department cannot ascertain as to whether the EPF due has already been paid or not. In the same time, in the same brief, the opposite party in the affidavit contended that they don't have a single scrap of paper to ascertain the fact, essentially. In this prevailing circumstance, the department neither in a position to ascertain as to whether the petitioners have paid the EPF dues or not, or in the and at the same time they don't have any document to support the case, support the prosecution launched by them. Therefore, the prosecution launched by the opposite party against the petitioner is destined to be a futile exercise in particular, futile exercise in the absence of any document supporting document. In view of the judgment of the Honorable Supreme Court and saying subjecting the continuation of the prosecution against the petitioner is definitely a wastage of the court's time and perpetuate harassment to the petitioner. Hence, he seeks the indulgence of this court for questioning of proceedings. I'm in agreement with the regarding the fact that the department has no legacy document preserved to ascertain as to whether the petitioner was paid the EPF due or not, and they can't sustain the prosecution in the absence of contemporaneous document. Hence, I'm glad to allow the petition and the proceeding under so in question. Yes. Yes.
Term 93. It was trigger for filing objection and filing objection. I have served copy to my friend also.
Just now, give the copy, but I request your lordship may take it up at 2 o'clock. My Lawrence Senior may go, but the date may be fixed in presence of Mr. Mishra, Lawrence Senior Counsel, because he is there, he is on the way.
I have a difficulty.
I will inform.
You may not come,
Yes. I will inform him the date because in his presence the date must be fixed, my lord, as per his convenience.
Not between 22 to 27.
Yes, and it will be in the first week or second week of February.
Any day can be noted except
Second week of February.
Let him come, he is on the way, my lord. At 2 p.m. date will be fixed.
Yes.
I will inform.
You may not come, no problem. Yes.
You only verbally you are welcoming. There is some music also.
Oh, I agree.
Welcoming somebody playing music.
When I was additional training counsel in 95, my senior was the state counsel for the
He doesn't understand to whom he is introduced.
I understand. I want other person around us to be enlightened.
We have the privilege to learn so many things
Yes,
from him. Yes.
Lord, I'm told that the matter was mentioned 93. That
He has filed the objection to that.
counter, we'll file the counter. Copy has been given.
Copy has been given.
Oh, copy has been given.
You would be filing a response to that.
I don't think so, my lord. Last time he said that there is 73, 173.8 is open. I have filed a charge sheet. We verified. There is nothing. No case pending except PML. That's the straw point that I will argue. For a family event, I'm here on the next week. I'm bound to be here. And if your lordship can take a for 10-15 minutes, I will complete. Looking at your lordship board, I'm not
21st, your lordship.
25.
He is available on 21st. You are saying that from 22nd to 27th, he will be remain absent.
In any case, 23rd is a holiday.
No, let us see. We'll keep it on 21st. Let us see.
21st,
what happens.
That's right. If there is something, I'm
Yes.
there. I will intimate.
We'll try on 21st. If it
21st.
happens, then otherwise we will see.
I will put a note, everything I
Yes.
put. It is easy for to decide.
Yes.
But there are 3 judgments. I don't know what they have filed. I read it and tell you. Mention. Okay.
21st.
21st. Matthew.
Please intimate to Mr. Agarwal.
Yes, yes.
Yes.
14.
Yes. Yes, sir.
My lord, this is matter, my lord, I had first round, I had come before lordship directed to raise the matter before the court session over the matter at the appropriate stage. That is, my lord, I had come against the order rejecting my discharge application. So your lordship directed at the appropriate stage at the framing of charge. My lord, the learned court session of the matter thought it that the contour and spirit of your lordship was misconstrued by the learned trial court, that at the appropriate stage means at the trial, my lord. One part of the, then second, the learned trial court has dealt with the main issue which has been carved out the petition, that in the wake of death of the informant, the bribe giver, whether the case prosecution falls apart or not. Then your lordship, the secondary, the lordship has given secondary, that means the overhearing witness. But the overhearing witness is crystal clear. He has not whispered 7 except saying that the accused, the informer, the bribe giver gave money for the demand, only demand for the, but the gratification has never been whispered.
Let us see the
scenario.
Let us see the impugn order. What? Impugn order is at Annexes 4 series.
At page 112, my lords. 112.
Yes. Yes.
Ascribing causal reasons, my lords, particularly relying on the judgment of Supreme Courts in the Niraja Datta case, my lords. Even in the absence of any supports of the decoy or the death of decoy, my lords, it is up to the prosecution to rely on other circumstances of evidence.
That's the.
Their main contention is that because the decoy died.
Neeraj Dutta. Neeraj Dutta judgment you have?
No, that the court has relied upon by the state.
And let us see that judgment.
I have gone through that. That in that case, the factual aspect is somewhat.
But let us see what are the ratio laid down. That's the very important judgment.
Yes, yes.
The trial court rely upon that judgment.
Yes, that was.
Okay. Simply then. Yes.
Next step.
Yes, he'll give it. Yes, next.
75.
Password may not be possible, or we'll give a date. Okay. Okay. For petitioner, the earlier counsel has given us. Also, he is entering appearance for petitioner after taking no objection from the earlier counsel. Leaves the matter.
Pardon, Lord. So that is that on 20th. I'll make an application.
How?
Black, deep black.
Yes.
Item 80.
May I please your lordship? May I please your lordship?
Yes.
In the impugned order dated 15th April 2021, the learned ADJ, first ADJ Raurkela, has limited the time period of claim of monetary relief from the date of the order of the interim monetary relief, that is 16th February 2019, to date of decree of divorce. That
I'll
is
issue notice, madam. Let us see.
My lord, I am appearing for the opposite
Okay.
party. My lord.
Okay.
Yes.
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 Yes, madam.
Yes. The learned first ADJ Raurkela has limited the time period of interim monetary relief from the date of order of monetary relief, that is the 16th February 2019, to date of decree of divorce, that is 16th October 2019, even if the order of interim maintenance has not been challenged anywhere and the order is final and intact. Due to such impugned order dated 15th April 2021, the petitioner is deprived to get the order amount of maintenance since 16th October 2019 till today, which is around rupees 4,41,000, my lord.
Yes, what do you say?
My lord, I'll let her complete your lordship. If your lordship will have.
You have completed this
My-
at least. Yes.
My lord, this is a case, your lordships. If your lordship will see, there are several litigations has been disposed of by this honorable court, which has been deliberately suppressed in the present proceeding. In the
Have you filed a counter?
No, my lord.
You file a counter?
Yes, your lordship.
File a counter.
My lord.
Responding 1 will time to file counter, let him file. Yes.
Right.
Let the counter come. Yes.
81.
Whatever according to you has been suppressed, you disclose those things.
Yes, sir.
Yes.
I'll give all.
Yes.
81.
Yes.
Well, this is that matter relating to 138 of NI Act. I have my phone. The other side law is on there, but I have
Three matters, huh? Three
Yes,
matters.
yes. Here that matter with the money was given to the son of the petitioner for the purpose of getting a seat in the government medical college. Because the son of the petitioner will be giving false impersonation that he is one of the member of the JE.
Whatever, but you have given the check to
I had issued the check because when she could not get the seat for her son, the informant, then they came and demanded the money in the house of the.
You say that is not legally recoverable.
I said yes, sir.
Why it is not legal?
Because the date which has been occurred, your lordship will kind of have a glance to the decision of the case of Madras High Court.
So give me.
Your lordship. The first one.
Your son has taken money.
Yes, your lordship.
Fraudulently from the informant, saying that I'll arrange a seat for you in the medical college. And he couldn't do anything. Obviously, it was cheating. And all of them came to your house.
Yes, sir.
They started attacking whatever.
Yes.
You have given a check.
Yes.
Okay, that is dishonored. And the liability was known to you while giving. While issuing the check.
Yes.
You were fully aware that there is a liability.
But
created by your son.
Yes.
And accordingly, you issued the check.
Yes.
So then it is recoverable.
Well, once, unless there is a legal enforceable debt, that is the minimum requirement
Let
of
us
the
see what is
statute.
legal. Which paragraph?
Paragraph 5, your lordship will find. Very
paragraph 5 of?
That
Running
page 11. Page 11 of my compilation.
Yes, 11. Yes.
The question for consideration is whether the respondent would be entitled to maintain the action for recovery of the plaintiff claim. Here, I must clarify that here this matter relating to a suit. Last occasion also you will also put a question to me whether even whether suit will be maintainable or not. That I will have to examine. Here this is a case, my lord. I am placing that this judgment involves that for the purpose of getting admission in the government medical college, the money was paid and for recovery the suit was filed.
and it was brought to the Honorable Madras High Court, and the Madras High Court, while dealing with the different Supreme Court decisions, held that since this is debt is arising out of a immoral contract, so which is hit by Section 23 of the Contract Act, so that cannot be illegal. That is not
not recoverable.
Legally not recoverable. And for my case, it will be directly fit to my case. Your Lordship will find the next judgment, page 15.
Page 15, huh?
Yes, next judgment.
No, page 11, which part? Which part?
Page 11.
Yes.
Page 11, paragraph 5. It should be noted that the suit is based on original loan and not
paragraph.
Paragraph 5.
Yes. The question for consideration whether the respondent will be entitled to maintain the action of recovery of
the specific
the plain claim. It should be noted that the suit is based on the original loan and not merely so-and-so agreement. And the specific is of respondent is that to consider the promise of the applicant to obtain a seat in the person so-and-so or so-and-so. This is immoral debt.
Yes.
Not recoverable.
Now your Lordship can have a to page. I'm not wasting your Lordship's time. Page 14.
14,
compilation.
14.
Page 14.
Yes.
Paragraph 11. Following these decisions, it has to be held that the instant case falls clearly under the maxim in pari delicto poter est condito precedences. The respondent must have known when she paid rupees 15,000 that she was paying the money for an
illegal object.
Yes, your Lord.
Yes. Yes. Next.
Next is Delhi High Court decision that relating to 133 NIR.
What does it say?
They are also relying upon that Madras High Court judgment. Delhi High Court also quashed the proceeding.
Where is that para?
That paragraph 12.
12, huh? Yes. Yes.
No, sorry. That is paragraph 13, page 1196. In that SCC reference I have given. Page 28 of my compilation.
28.
Last paragraph. Last paragraph.
Yes.
In the present case, neither party is a victim of exploitation. Both had voluntarily and by their free will joined hands to float the law. Therefore, in terms of the Supreme Court decision in Sitaram versus Radhabai Supra and Mohammad Salansan themselves, the parties being a part of pari delicto, the doctrine would apply and the sum of rupees 80,000 could not be recovered in a court of law. Meaning thereby that there did not exist any legally enforceable debt or liability for the discharge of which it could be said that the check in question was issued. Consequently, Section 138 of the NI Act would not be attacked.
Yes. Next judgment.
Next, your Lordship, that recent 2018 decision, Karnataka High Court. That decision also, your Lordship may kindly glance to page.
Yes.
Page 35 of my compilation. Paragraph 25.
25, yes.
Yes.
It is seen that there is an absolutely no allegation whatsoever.
It is seen that there is absolutely no allegations whatever that the accused has taken this money as a loan or debt or as a liability at any point of time. It is clear cut case of the complaint.
Securing a job.
Yes, your Lord.
Yes. And this is 138?
This is 138. Except Madras High Court judgment, all the decisions I have given relating to 130.
Next, come to Kerala.
Kerala, my lord, there, that decision, that is the case concerning a compounding or compromising in a case of 376 IPC. When the compromise was not effected, the money was demanded and check was issued. And the Honorable High Court of Kerala held that the purpose for which the money was given and the recovery has been sought for, that is immoral, against the public policy, against the statute. Because when the offense provides that that is non-compoundable, you cannot adopt that process backdoor method to get it compounded, and when on being unsuccessful, you cannot make a demand.
What Bombay High Court says?
Bombay High Court decision also there. Here, Bombay High Court decision, your lordship can have paragraph 3.
Yes.
That was one of the point was raised by the present case in the complainant. The accused did not dispute the fact that he had issued the check under the signature and had received the notice exhibited from the complainant, but outrightly denied the complainant and any liability on the ground that the complainant was doing business for money lending without any requisite license of money lending, and that the complainant has failed to prove.
I read it. Come to this judgment. Last judgment. Madras again. Madras.
Then your lordship can recognize another judgment of the Madras High Court.
Yes.
That paragraph page 45.
Yes. Yes.
Madras High Court has taken note of all the decisions, including the Karnataka High Court decision. The lordship can have gone to page 54. Though securing a job at abroad may not be unlawful object, but what is unlawful is consideration paid to it, and the consideration having been already paid by the appellant, the illegality stood completed on the part of the appellant, and inasmuch as the appellant would have to rely upon the illegality to make out his claim and enforce the same. Here, the doctrine rule of pari detecto, you'll also next page 55. And finally,
this is the law. This principle is applicable.
Yes.
Doctrine of rule of pari detecto.
Yes.
Yes.
Thereafter, the in 2020
Okay, I understand. Yes. Anybody is there to oppose?
Oh, Mr. Sahu, Lalit Sahu was there.
Call him. I understood it. You have a case. A immoral debt cannot be recovered.
Yes, your lord. That is what from the day one I want to break your lord.
That's the law. Call him. I'll just pass it over. Otherwise, I reject it. Yes. 82. All the 3 checks, huh?
Sorry.
3 matters, 3 checks.
The next one, there are 2 checks.
Then why 3 matters? Then?
3 matters, that one. 3073 and 3881 relating to one case. In 3073, the challenge is that the petitioner filed a petition before the magistrate to call for a record of the another GR case in which the affair was lodged against her son, because there the complainant has given certain contradictory statements, and that petition was rejected. Therefore, I came before this honorable court in 3073.
What is the stage, by the way? Trial.
Just evidence has not been come only.
Call him. Call him. Otherwise, I'll keep it in Monday. Call him. Otherwise,
in worst case, if your lordship I am not finding,
I'll keep it.
Yes, today I am lucky enough that
I understood it now. Yes.
82.
In 82, my lord. The order of enhancement is on the challenge, my lord. The last occasion, my adversary was not present and lordship adjourned this matter. The question was the wife
enhancement of maintenance.
Yes, madam. The wife has so much rejected. All along, I am interested to take my wife.
Where is he? He has to appear.
Again, appear question, nobody is coming. During proceedings, she has categorically stated, I have so much rejected.
Last time anybody appeared?
No, last thorough भी न थे, तब approval थे. Though in the both the courts will have categorically stated, I am ready and willing to take.
That's right, but in the absence of the wife, I can't. Just talk to your next short date would be.
What last chance?
Non-APS for opposite party today. in the interest of justice, adjourned to so and so, it is made clear that on the next date of hearing, no further adjournment shall be given to the opposite party. Matters are there.
24th, maybe 24th is the top of it. Satish,
First week February, good. First or second week. Yes, next.
83.
Madam.
And for the opposite party, Your Lordship, last occasion, this is regarding that my submission was that notice issued under the DV Act is not a, they have come challenging cognizance order. My submission was that is a notice only under section 13 to respond to the respondent, and that is not an order of cognizance. Because, and I had given him a copy of the Supreme Court order also. Judgment of the Honorable Supreme Court, my lord. Which says that the complaint under the DV Act and the complaint under CrPC are completely different. So 190 will not be applicable to this case.
Yes.
And this is only a notice served under section 12 is an application to the magistrate. And it is a notice is sent under section 13 to respond. They have come challenging the section, that notice itself, saying that it is an order of cognizance, which is completely misconceived and
Service the board.
Who opposite party?
Who is a
Petitioner ଆସିନାହାନ୍ତି କହିଲା ତ ତାଙ୍କୁ କହିଥିଲା ଜଜମେଣ୍ଟ ଟା ପଢିକି ଆସିବାକୁ
My lord, that is on behalf of that is from Kumar Prasad. That is adjournment.
Yeah. Adjourn कर दो short date लिख के. The request made by your petitioner. Yes. Yes.
84.
My lord, ଖାଲି ଜଜମେଣ୍ଟ ଟା ଦେଇ ଦେଇଥିବେ ଆପଣଙ୍କୁ ତାଙ୍କୁ ସେଇଦିନ ଦେବେ
Give you copies. Yes.
ନା ତାଙ୍କୁ ତ ଦେଇ ଦେଇଛି already but
When I'll hear. Yes.
84.
And he is getting the same also last time also he has taken the time. And that is again for a
Yes, it came. Yes. What is this matter?
That is the challenge that the 125 proceeding matter. For crossing of the death and the order by kindly be.
My lord, in this matter,
They have challenged the order may be same.
my lord, in this matter, I have filed certain documents. On the 10th of January, I have filed some documents. I think it is not common record. Along with this thing.
Show me what are the documents.
Documents, my lord, what is happened?
See, these are maintenance petitions.
My lord.
And you have taken a stay.
My lord, can you see? Maintenance petition is based upon the true facts to be disclosed to the court regarding her financial capabilities. In her affidavit and evidence, affidavit before the court below, she has not disclosed lots of things. Her entire financial status, everything. She has not disclosed. Why we pointed out all these things before the court and moved an application that's under 340. My player is your lordship. She has to, the preliminary inquiry is to be made because I have given clear-cut documents showing that she has hidden all these facts before the court in the form of an affidavit. My prayer is your lordship, a 340 preliminary inquiry has to be conducted. Once it will be found that whatever she has disclosed is correct, then I don't have case. If she has found that she has not disclosed.
No, what are you seeking here in this petition?
I am seeking your lordship because I have moved an application on section 340 instead of directing for an inquiry, your lordship. The matter has been lingered because ultimately what will happen, your lordship, in 125.
What is happening in the marriage front?
In the marriage front, your lordship, she has deserted her husband. She has himself come out from the company of the husband.
No, have you filed any divorce petition or anything?
No, divorce petition so far. I have no idea that his divorce petition probably I am not administration. So far they have not filed. I think they are contemplating to file the divorce petition. Only thing is my prayer is your lordship. A preliminary inquiry to the affidavit has to be made in a separate proceedings.
Why are you complicating your life?
My lord, what has happened? She has filed a DB case also in which the same similar affidavit has been filed in the DV proceedings, your lordship, it has been stated.
But at the same time, you don't want to leave here.
No, no, my lord, I don't have any
Then why
problem.
have you not proceeded for divorce?
No, I think I have
You
to take
can't,
instruction. No, no, I will take
You
instruction.
can't stay together and keep on fighting.
No, 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 I am not. We are not interested on that also, because if you, I will just, if your lordship may kindly keep it next week, or then I will obtain whether divorce petition is filed or not. What has happened here in the 340?
See, what he says is you have concealed several factors. He has filed 340.
Yes.
It has to be inquired into.
But that much only.
14, huh?
Yes, 13 and 14.
Yes.
What is the honor? He has challenged for crossing of that sale. The
Yes.
notice has been issued and filed the put up for objection. Now,
So-
what method then against him?
And your lordship, similarly, she is in a DB petition also proceeding some affidavit,
Maybe.
and that court has already directed for a preliminary inquiry and stayed the maintenance in the DB proceedings also.
That doesn't mean that he will not file the defense.
No, I am saying that in that proceedings also, you have filed the same affidavit, and the court has directed in preliminary inquiries to be conducted in the affidavit, your lordship.
But that people government servant, public servant.
No, not in this. In Rajin Sports and Neha, it has been clearly stated, your lordship.
How are you agreed by this? How are you agreed by this order?
My lord?
How are
No,
you
no, I am not agreed. I am just, I have filed a direction that to, because your lordship in
You have
340.
moved an application under 340.
240, that has been instead of, the preliminary inquiry has to be made if the court is satisfied that.
Where the court says that I will not do it?
No, no, court is, my lord, it is been, matter has been lingered.
Not linger. See, this order is passed on February 2024, and court is making all out efforts to settle the dispute between you and your wife, and you are moving 340 application. Still the 340 application is entertained. What do you want?
No, I want that your lordship may guide that my 340 application be disposed of first.
It will be disposed. You have filed.
No,
Why are you?
No, no, my prayer, your lordship will kindly see. My prayer is only that to that effect that it is to be disposed of.
It should be disposed of. Why should you?
My lord,
If you have moved the application, it will be disposed of.
no, no,
What should I say?
my lord, sees, because on the basis of that affidavit, sees the following of the maintenance case, your lordship. My grievance is, your lordship, unless that 340 will be disposed of, then how can we?
Petitioner is the husband of opposite party number 2. The petitioner has invoked the jurisdiction of this court under 482 CrPC, exploring the following relief. The by the order dated the perusal of order dated 29 to 2024 and 8/4/2024 reveals that the trial court has been making all out efforts to see that the parties would settle the dispute and settle the dispute. The reconciliation effort made by the petitioner, made by the court, yield no result. Yield no result. Why yield no result? At the same time, the petitioner, being the opposite party to the proceeding initiated by his wife, moved an application under section 340 CrPC, entry alleging that his wife has concealed many material from the court. Therefore, criminal prosecution ought to have been initiated against the said application was entertained by the trial court. At this stage, the petitioner has approached this court, apprehending that his application may not be inquired into. Application under section 340 CrPC may not be inquired into by the, may not be entertained by the court below. The apprehension of the petitioner is not well founded, and moreover, on the basis of his apprehension that the application may not be dealt with in accordance with law, no order to be passed under while exercising jurisdiction under 482 CrPC. Therefore, the petition is premature, hence the same is dismissed. At the same time, it is expected that the trial court would do well to see that the application moved by the petitioner is dealt with in accordance with law. Yes. Dispose of. Next.
My lord, second matter, maybe kindly keep it some other day. It is not pertains to this maintenance. It is not.
One first matter 1994. Second matter, what is that?
Second matter, my lord, is pursuant to the DB case. In this, my lord, in this matter also the DB case, because of this 340 application, the DB
Your
case.
client, I think, is decided to keep on fighting.
No, my lord, that is not that. It is in the, my lord, it is on the DB case on certain other grounds. So therefore, my lord, may kindly.
Instead of appreciating the effort made by the trial court.
My lord, this is a altogether different. It is not on the maintenance. There is no state also, my lord. It is a initiation of a DB proceedings against the sister-in-law who is a married sister-in-law who is not staying in the sharehold house, and the mother-in-law also, he is also staying with the sharehold house. Because
have you moved an application before trial court? Yes.
My lord,
have you moved an application saying that I have nothing to do with this?
it is not maintainable because of that.
Move an application, get an order from the trial court. Trial court will drop you. Why immediately rushing to the 482 court?
Trial court has the jurisdiction to decide it.
My lord, it is.
You move in a specific application. I give that liberty. Let the trial court deal with the contention you raise, because you are the sister-in-law
and they are not.
I know. You are not in domestic
relationship. So therefore,
you have to tell that to the High Court, trial court. Why have you come here?
My lord, then with that liberty, then my lord.
That's what I'm saying.
My lord, with that liberty.
They have already filed their objection.
Where is that objection?
Objection before the trial court.
My lord, with that liberty, may be disposed upon that liberty so that I can move an application.
It is 1002 of 2020. Petitioner number 1 is the sister-in-law.
Sister-in-law and mother-in-law.
Sister-in-law, and petitioner number 2 is the mother-in-law of opposite party number 2. Opposite party number 2 has initiated a proceeding under section 12. 12, no?
My lord.
12 of DVA, being Miss case number 170 of 2023. So cause notice was issued to the present petitioners by the trial court. The Mr. Divedi counsel for the petitioner submits that both the petitioner do not have domestic relationship with the opposite party number 2. Therefore, the proceeding initiated by the opposite party number 2 against them under section 12 is not maintainable at all. Counsel for the respondent, on the contrary, submits that the petitioner has already filed an objection before the trial court, taking exactly the similar ground. Regarding head to the aforementioned, I am applicable to do that the trial court should deal with the objection and pass a speaking order in the objection.
Well, I will move an application for deletion of the parties that
the petitioner is also given liberty to move a specific application in that regard. In that regard, with this liberty, the petitioner is disposed of. Yes. Both
If the stay orders are there.
Dispose up, then you know what happens. Yes. Both the matter dispose of 85. Yes. Yes.
Next item, my lord.
85.
85, my lord, is a case, my lord. The prosecution commenced with law of elopement, then culminated marriage. Now witnessing happy conjugal life, blessed with one child, my lord. With your lordship's direction, the victim has come.
Accused and informant is married.
Yes, accused is married together. A victim has come as per lordship's direction. He's
Where is the accused?
physically present.
Where is the accused?
My lord.
Accused.
Now, accused of Chennai has not come, but advocate, I'm appearing correctly.
No, I don't know. Accused is in Chennai or in judicial custody or in committing crime right now. I don't know.
The victim is here.
But that's right. But online, let him appear at least.
Then next.
Why this lady will be coming on unnecessary?
Because
I'm just passing it over. Just see 3 o'clock. Tell him, speak to him and let him appear.
I'm contacting.
3:30 I'll take it. Unless this lady will keep coming. They are married. Both of them are married now.
Lord, I instructed her, so he come through.
Okay, it's all right. Both of them are married. Just ask.
The wife. Now she's the wife, Lord. Wife has come. Joint application.
Tej Pratap, who is appearing? You are appearing? Who is appearing?
Yes,
You are
sir.
appearing?
Yes, sir.
Just ask her whether she is married to the accused and we happy.
My submission before your lordship may send it to mediation.
Settle it. Why unnecessary? What is happening in the marriage front?
My lord, married, having two children, and most of the times, according to the petitioner, most of the times she was quarreling with him and the family members, and also threatened him to commit suicide.
Till you have two children.
Still, I have two children.
What I just send it. Just take it up. If you can stay together, it's all right. The phone granted appearance on behalf of opposite party number 2. This the dispute is arising out of a matrimonial discord. Therefore, both the counsel appearing for the parties conjointly submit that they can explore the possibility of a settlement. Hence, requesting sending it to the High Court Mediation Center. Our Mediation Center of awaiting report. And shall I put it in the second week?
Second week of February.
February.
Before the
Second week or third?
my lord, before this court.
Yes.
Mediation.
No, mediation. I have sending
Yes,
mediation.
mediation that
Awaiting mediation report. I am putting
Yes.
it after third week.
Third week.
Awaiting mediation report.
Yes.
List the matter. Yes. High Court mediation.
Yes, High Court mediation.
Date will be fixed and intimated to you.
My lord, interim order to continue.
Interim order to continue.
Letting non paying.
Yes, I am paying.
Interim order. That is the conditional interim.
Yes, that is condition. I am paying also.
1 minute. Let us see. Yes. You have to pay it.
Yes, I am paying. Oh, please.
87. 87, I pay 1 week after. Along with my CRMC number 306 of 2020.
Okay. List it on the request of Mr. Japurla. List the matter so and so. Interim order. Yes.
88.
In 88, on the last occasion, we had given a draft settlement proposal, and Mr. Artha was supposed to get back on that, my lord.
Yes.
I have seen that. I have also taken instruction. We are agreeable with this. Very good. We are disagreeing with but one just suggestion. There they have said, they have said that on this settlement, the whole case should be passed. Only I have one problem here. If the case is passed and they default, then I am left with no remedy.
No. What I suggest, my lord.
No, 1 minute. Yes. You want that let the entire payment be made thereafter pass. That's what you are saying. Yes, Mr.
What I'm suggesting, we will issue fresh 8 checks, my lord, so that he has a cause of action in case if any of the
No, can't keep on fighting. And all these things will be checked. Dishonor again, he'll run around.
No, and this is just my suggestion. Otherwise, it has to be kept pending till the entire payment is made in the next 9 months.
Pushing the state till this whole 8 months period.
You know what I'll do is, I will quash it and reserve your right to revive it if any failure takes place. That is more in. Suppose she gives 2 installment, 3 installment. If he doesn't pay subsequent installment, then you will revive your original complaint.
That is public.
That is the understanding. He will revive it.
Yes.
And the money which he will be paying, that will be forfeited. At least that threat will be there. Obviously, that will be forfeited.
I'm okay with that.
Okay, give it. Give that understanding. The money which he'll pay will be automatically forfeited and the complaint will be revived.
Yes.
On your application. So that at least that threat will be there.
Yes.
Otherwise, there will be default. Right now. Petitioner is the accused in. I'll cross through, I'll make it part of the order. Right. No, at the instance of opposite party number 2, opposite party, 1cc case number 6131 of 2024 came to be registered against the opposite, against the petitioner against the petitioner regarding an offense punishable under section 138 NIA. The total, what is the total amount of
9 crores.
9 crores. The opposite party has initiated the proceeding for proceeding under section 138 NIA for the dishonor of the check of 9 crores issued by the petitioner. Petitioner. The petitioner. Now you have filed for what?
I filed for quashing of the summons, my lord.
He is seeking quashing of the summons.
Because I'm not going to the merits of the case.
The trial court issued while taking cognizance of the offense, issued summon to the petitioners for in the ICC case number 6131 of 2024. At this stage, petitioners approved this court seeking quashing of the entire criminal prosecution initiated by the opposite party. When the matter was heard at length, during the hearing, the parties have agreed to settle the dispute. Subsequently, Mr. Gautam Acharya has circulated a draft settlement proposal to Mr. Praful Rothar and senior counsel appearing for the opposite party. Mr. Rothar had taken instructions from his client and agreeable to the proposal. On the consent term, the proposal mooted by the petitioner has been accepted by both the parties. Therefore, the proposal is reproduced in the present order and form part of the same. The proposal signed by the counsel for the parties are placed on record. You sign the reproduce total term produce. Both the parties represented by their senior counsel and instructing counsel instructing counsel undertakes to the court that they will abide by the terms of settlement. Terms of settlement. In view of the settlement terms, the proceeding initiated by opposite party against the petitioner, being ICC case number 6131 of 2024, is quashed. However, it is made clear that in the event the petitioner fails to comply with the terms of the settlement at any stage, petitioner has a right to, opposite party has right to revive the complaint petition by moving an application before the trial court. In that event, the installment already paid then by the petitioner will stand forfeited, and the opposite party can initiate the opposite party can move an application for revival of the complaint case, and the complaint case shall proceed in accordance with law. With this observation, the petition is disposed of. Yes.
Urgent certified copy.
Okay. See, Mr. Acharya, just tell your client, if he pays two installment, then stop, then those two installment is forfeited.
I understand.
And the complaint is revived.
I understand.
Yes.
Obliged.
89.
When is the date?
That time, the report is there. What's the mediation report that can be?
It's successful. There is a chance of settlement between the parties. Wait. The Metro has already been referred to Mediation Center and the High Court Mediation Center. No, Kotak Mediation Center. High Court Mediation Center. The same fixed on 31st January 2025. Please the matter of yes.
90.
Give second week. Yes.
Yes, already appeared.
Acha, so and so entered appearance on behalf of the opposite party and seeks 1 week time to file a counter. Let him do so within 1 week. Please the matter.
My lord, what did you say?
Interim management made shall continue.
Interim, that is no interim.
Hmm?
No, it is a, some of the POCSO Act.
No. The petition is granted liberty to move appropriate application before the trial court seeking adjournment. That is there. That is there. You move application.
I was not on bail.
What to do? You tell me.
Marriage, no policy action.
You are absconding. That's the problem.
Lordship, I have annexed the 161 statement.
What does it?
Here, Lordship can have page 23.
NVW is issued against you.
Yes, sir.
Show me NVW. I'll find out a way.
That order I have.
Just tell me the NVW. I'll stay and protect you for some time and ask the trial court to decide the application same day on these grounds. You will be granted bail. Why to? Let us go.
Then I will file that NVW.
You show me the NVW if you have. Right now, I'll do it.
I have no, that order is not with me.
I'll put it then on the 31st.
And I would, another difficulty is unless until I appear, madam, that certified copy I could not get.
I don't need certificate copy. You give me just now. I'll pass the order. Forget about certificate copy. Nowadays, don't tell me. You can get the copy immediately.
No, certified copy.
I don't need certificate copy. You show me the date of order at least you tell so that I can give dictation.
Your lordship fixed to Monday.
Monday. For interim order, not for final. Monday will be very tough. I think let it be 22nd. 22nd.
My friend is appearing and the informant appear.
I know you are at least entitled to bail. I'll pass such orders so that you will be out. Your absconding thing will be taken care of. Thereafter, we'll see what we can do. At least temporary relief you should get.
His personal appearance may be disconcerted.
Yes, don't
his
bring.
Appearance may be noted. And
don't bring. Don't bring.
Always.
Yes.
92.
Number 1.
Mr. Tripathi, Tripathi. Call him. Can you ask your instructing counsel to get the copy in the WhatsApp today? I'll just 3:30. You just ask him even if he gives you the date of the order, then at least I can protect you. See, he's absconding. Just check it up, huh? Otherwise, it will come on 10 seconds. Okay. Yes. Yes. 90?
My learned friend is appearing today.
For opposite party? Opposite party 1. He entered appearance, seeks 1 week time, and yes. Yes.
My lord, that interim order to continue because I will have to file an adjournment application.
Interim. Yes.
94.
Please, my lord. In this case, present petitioner filed this case for quashing of proceedings on the basis of settlement, my lord. Matter has already compromised in between the party, my lord. Both the present petitioner and informant are both blood related.
Okay, you bring them. What 307. Injury?
Simple.
Injury report also you file.
No.
Charge sheet, madam, charge sheet has been filed. Just see. check.
That has been filed, ma'am. Other
94. No? Just check it up, madam. Charge sheet. Charge sheet is filed. Why are you saying that?
before charging matter has already been settled, my lord. For that
You just said that charge sheet has been filed. 307 is not there. 307 is there.
Sorry.
Huh.
Injury is simple, my lord.
Show me that. Show me that injury is simple.
Yeah, let it on next week.
Simply urgent. What? Get the injury report and get the petitioner sent out.
Is
Yes, madam. Anybody is appearing?
well, this person considered a private opposition party.
Who is
He wrote a letter to the Registrar General and copy also given to my advocate.
I gave a direction to the IIC Baleshwar PS.
Yes.
Now, what has he done? Committing reference.
The ISL already communicated to all the opposite party. One of the opposite party was 7 is defending to the superintendent is present before the lordship. Instruction, sir. कौन instruction लिखी थी?
Yeah.
The last page, my lordship.
Yes. That I read. Why do this? You have served. Have you served? The child is.
He has already handed over the child to the district child protection.
What is the name of the petitioner?
Sumati Mani Sahu.
Sahu. Who is Ajit Kumar?
She is the mother and the petitioner number 2 is the father. Actually, hurdles came when this Learned Court bill passed in negative order against us. That's why they are everybody is fearing.
He has kidnapped the child. Now, girl child is not safety. Will not be safety.
She is already as a child. First one is a girl child. She is now reading in class 9. This next one is also girl child. She is now reaching 9 months like this.
This is the Child Welfare Committee.
Yes.
Yes. For a moment, let's make on the page 61.
DCPO Baleshwar is instructed to conduct an inquiry under the circumstances. The child was admitted to so-and-so. Further requested that the child is abandoned one, and so it is felt necessary to publish the photograph of the child in at least 2 daily days. So. Yes.
My lord, let's see the page 61.
61.
Annexure 13, page 61.
Yes.
The observation learned code below. That is
on your application.
My lord, my petition. That is because he is observed that I am just reading, my lord. Last paragraph.
Accused person on behalf of the accused persons. Huh?
Yes.
Okay, you move the application.
Yes.
Person in this case wherein the prayer has been made to this court to deliver the custody of the child to so and so. Yes.
This Lord could be little bit sentimental and passed
Where
on.
is that?
Once says theft a child, he should not be.
Which paragraph?
This paragraph, last one, paragraph, not sir. Above to one, mane just be below last paragraph, above to that.
I have perused the record.
Yes.
And along with the other.
Yes, may I read my note?
Yes, yes. read it.
After receiving the information, the IO in case started investigation, and during the investigation, he found that the present accused petitioner were actively involved in the case. In this case, after completion of this investigation, he submitted charge sheet to the court, in which the names of the present accused persons are mentioned.
In the prime accused.
Uh-huh.
For the
Prime accused, yes.
So and so. One of the accused, namely so and so, and who is the biological mother of the female child, presented the petitioner, prisoner's petition so and so, overhead the female child to her, but the same is rejected by the court. Is a well-reasoned order, and the custody of the said female girl child was handed over to the. Yes, madam.
Because this order will not be far.
Everyone is fearing and not going to release because the court below has passed the order.
The court only said that you have not taken care. But how can the parents, the biological parents?
Worship. They have left the girl child in the hospital and they have taken the male child in their custody.
This is the what to do. This is the societal pressure. Everybody.
Then again, I came back and returned this child to.
Kidnapping the boy, abandoning the girl child. That's the case. But this child who has been abandoned, she is not involved. She is not basically the subject matter. They are claiming the biological. What about the boy?
Boy is fine. She is with his father. They didn't have any objection. They are comfortable. They also now they are coming and have a relationship with us. They want that your child should come back, but the law is obstructing us.
Right now, petitioner is in this petition. Petitioner are seeking quashing of quashment of the order dated 1/8/2024 passed by Lieutenant JMFC Baleswar in city case number 318 of 2024.
Collective court na.
2024, whereby the application moved by the petitioners for delivery of the custody of the their daughter has been turned up. Has been done. Petitioners are accused in FIR number shown. Allegation against the petitioner shown. The petitioner the prosecution is alleged against the petitioner that they have kidnapped a baby boy born in the hospital by abandoning their own biological their own daughter. They have been prosecuted for the offences as alleged in the FIR mentioned above. Are you on bail?
My lord, yes, we are in bail.
Both the petitioners have been admitted to.
As per direction, this is High Court.
After they are facing the trial. At this stage, they moved the application seeking delivery of the custody of their daughter, which has been turned down by the trial court by the impugn order, inter alia, stating as under. I have perused. Page 61. ये paragraph लिखियो. I have perused and the next paragraph लिखियो. Next the paragraph. ठीक है. In the paragraph. Notice was issued to the who are they? The opposite parties. The opposite party number 7 and 8. the custody of the child is under the opposite party number 7 and 8. The said opposite parties were directed to be served through IIC Baleshwar. The service is complete on them. They have addressed a letter to the registry of the Scott. No, they have it was sent to the registry. They appears to have sent a letter to the registry of why the registry has not placed it. Lately, that's Richie, no, they have appears. They have sent a letter dated 10/1/2025 to the registry of this court Interim stating agent. Interim stating agent.
দেবী শুনবো না
ঠিক আছে
না না আবার কপি আছে
the girl child was handed over to the opposite party number 7 and 8 by the child welfare committee by recording the order dated 19/4/2024 in the following terms. Following terms. The petitioners have approached this court by challenging the impugn order dated 1/8/2024 passed by the JMFC Baleshwar and praying inter alia praying, but they being the biological parents for the child in subject, custody of the child should be given to them. Which paragraph you wanted to show?
paragraph, last paragraph and above to that another paragraph.
No, in the petition. The petitioners have contended that they are the biological mother and father of the newborn baby girl.
Paragraph 5 and 6.
And baby girl. Therefore, they are not. They have not given any consent for consent for giving the girl and on adoption. Any law you have cited? Nothing.
Is this in POSCO Act, essentially Juvenile Justice Care and Protection of Child Act 1950. Powers of the committee starts from 29 and this is coming up to 40.
Yes.
They have given the detailed procedure, how to give, who is the child, how it is
Which provision you are relying on? Option Juvenile
ସାର୍ ଦିଅନ୍ତୁ ଏଇଟା, ସେଇଟା ଦିଅନ୍ତୁ।
There is no dispute that there is no dispute at the bar that raised by any party at the bar regarding the but regarding the parenthood of the petitioner so far as the girl child is concerned. Mr. Pari, let us counsel for the petitioner. Which provision you are relying upon? This is a different. These are procedure.
Yes.
Where does it say that the biological parents, even after abandoning the child, are entitled for custody?
This statute provides that in what circumstances the children can be handled to.
If the child would have been taken by someone else, if the parents claim it, automatically it will be restored to you. That is a different situation. But you have abandoned the child.
Yes.
Where is that provision?
The statute didn't, no such provision is there. But statute says that if a identified child is there, how it will be taken care of by this?
If a child of someone is taken away by someone else,
yes,
and he was rescued, it is automatically to be restored to the biological parents. This is the provision.
Yes.
It is the reverse situation.
It is reverse situation. There is
The biological parents have abandoned.
It is not a case of abandonment, my lord.
It is abandoned because you left your own child and taken the
admittedly, a crime has been committed by me because
you
of
just assist me. I am allowing you, but
yes, yes.
justify it.
I will make it research, my lord.
I
give you. Yes.
Justify it.
Yes. Note.
Partly so let us counsel for the petitioner has relied upon section 30 of Juvenile Justice bracket C and P Act 2015 and submitted that biological parents of a child of what is the
age of 9 months
of a child of 9 months 9 months is automatically entitled for the custody even in the fact situation of the present case, even in the fact situation of the parent present case. It is emphasized section 30 Roman 4 6 Roman 4 6 of the act which reads as under ensuring care, protection, appropriate rehabilitation or restoration of the children in need of care and protection, based on the child's individual care plan and passing necessary direction to the parents or guardian or fit persons or the children home or fit facility in this regard. He submits that a infant of 9 years, infant of 9 years is depending upon the breastfeeding of the biological mother. Therefore, depriving the child from depriving an infant from the breastfeeding is violation of her right enshrined under Article 21 of the Constitution of India. Therefore, the right of the child precedes over the guilt of the mother. He submits that by the paramount consideration is the right and welfare of the child, Therefore, he submits that the parents, biological parents of the child who alleged to have abandoned the child and kidnap another baby boy, and needs to be established in the trial. Till the trial is concluded, the right of the infant baby girl should not be taken away. Hence, it is inevitable under the circumstances that the custody of the child should be restored to the biological parents, biological parents.
Lordship may refer to section 40. First to A is says parents.
Yes, then
Section 40.
he also rely upon section 40. 40. 40.
That is restitution of the child. That is coming explanation. Lakshmi come the explanation. For the purpose of this section, restoration and protection of a child means restoration to parents. First, ingredient is parents. It's the prime objective of this.
40. Mrs. Maharana, counsel for the state on the contrary, submits that due process under the Juvenile Act has been adopted, has been followed, and the child had been given to the child care center. The trial court has rightly appreciated the facts scenario of the present case, taking into consideration the conduct of the accused person, and the safety of the girl child. The trial court has rightly rejected the application moved by the petitioner. I have taken into consideration the entire facts, and the document placed before the court, and for the opinion that the environment opinion that the stand taken by Mr. Padi deserves merit, and so as to protect the right of the girl child, who is the infant and mother-feeding infant has to takes supremacy over all other contention. Hence, the petition deserves merit according to detail out. That is the respondent note 7 and 8 is directed to restore the custody of the child to the biological parents. And there is some guidance. Some guidance is that somebody has to go and see where is that. That.
Let's see, may only reflect the annex of 15.
There is in the provision also. You people have not read it. I have to read it once again.
Yes.
There is a provision that every 2 months or 3 months
that is
report has to be there. Which provision is that?
That is in 36 or 37 like this. 37. 37.
Provision?
Yes.
Not read. Both of you have not read. I'll read it. I'll read it.
You may reflect one sentence.
There is. I'll find it.
Only one sentence. That is this birth certificate given by us. So take into consideration for considering the same. It will accept to their state side and our side also.
I'll just see the provision and correct it. Okay. But if you give in writing, but he is busy, but you are not busy. You give it.
No, I will try to.
And he doesn't have time to now study, learn. Now you have to learn. Prepare a note and give me. Okay?
I also ask my son to
let the juniors do it.
Yes.
This is the way of
he will do it.
Do it. Yes. Give a note.
Yes.
I'll correct it. Okay. On the basis of all provisions and all.
Yes.
And Article 21, the infant child right is also
protection of child. Yes. Welfare of the child is a paramount consideration. Yes.
On that, if you can get some judgment, give it.
Irrespective of the rights of the parents, the
child's right is paramount consideration is child's right.
Given to child's welfare.
Get some judgment. I will do it over. You should have read it and gave it to him. It is your job. Give a writing. And you also, huh?
Yes.
Please give it. I correct it. Correct it. Okay. Okay. Allowed.
96. Maybe. Petitioner seeks to challenge order dated 6/9/2024, my lord, at page 11, my lord. Petitioner, my lord, the case of the prosecution is that, my lord. The petitioner is the admittedly, my lord, wife of the government employee, my lord, who has expired in the meantime, my lord, before framing was charged. Government servant, the offense order says
you are one of the accused, you are a husband.
My lord, weight of 109 in this petitioner implicated, my lord. In the meantime, husband expired, my lord, before framing was charged. My submission before Lordship on the other day also, my lord, today, the aid of 109 can be run in the absence of the main offence under PC Act, my lord. One thing. Second, my lord, ingredients of 109 not fulfilled in this case, my lord. No here mentioned that the wife abetted the husband to commit the offence and with the knowledge that some property acquired with the knowledge of the petitioner, my lord.
Yes, in the
Two
first,
things, my lord.
insofar as the first submission is concerned, do you have any support?
My lord.
The case law?
My lord.
So,
that is, my lord. Paragraph 35.
Do you have any more copy?
More copy there, my lord.
Let to give it to Mr. Das also.
Paragraph 35, my lord.
Charge is been framed in your
Not framed. Before framing charge, husband expired. And the wife earlier came to this court, my lord. Your lordship, while disposing, directed the trial court to deal with the matter. When charge not framed, wife, the 109 can run against the wife, my lord, which is non-government servant. And another decision, my lord, your lordship, in E. Sonalta case, my lord. In that case also,
but it goes against you.
But
it says that non-PC offences can be tried.
Non-PC 109 can run alone, my lord. In that case, my lord, other 420, 120, other they are smart. There. For that reason, the apex court stated that
Let us.
109 cannot run, my lord. That is my whole submission. There are other offences are there.
Yes, 420, 468.
That can, my lord, go, my lord. That is my whole submission. But in fact, my lord, since there is other offences not there.
May I know the name of the judgment?
This is CBI versus Jitendra Kumar.
Jitendra, yes, ma'am.
Jitendra Singh.
The ratio in that particular judgment, my lord, has been watered down by the subsequent co-equal bench of the Honorable Supreme Court, my lords. I just bring to lordship notice, my lords. In the similar situation, my lords, the main accused died. The question was before the Honorable Supreme Court whether that the abetter can face the trial, my lords. Let me place it as small judgments. Charge sheet was filed against the main accused, who was a public servant under the provisions of the Prevention Corruption Act 1988, hereinafter referred to Act. I'm placing 2017.
Yes.
2017 SCC
All the
online,
accused were discharged.
SC page 2173. And also against the respondents accused who are non-public servants under the provisions of section 109 penal codes. All the accused were discharged by the London Trial Court, that is the Court of Special Judge, Chief Judicial Magistrate Salam. Aggrieved a criminal revision petition was filed before the High Courts. In the meantime, main accused dies. In this case, the same thing happened. The High Court dismissed the revision petition on the ground that the death of the main accused has resulted in abatement of the trial that the expert supports. And therefore, nothing remained for consideration. Aggrieved, the present appeals have been filed. Reliance has been placed by the London Council for the appellants on the view expressed by this court in paragraph 541 in the case of State of Karnataka versus Selvi Judge Jayalalitha, to contend that the High Court was wrong in taking
Para 4 Jitendra Singh is noted and para 5 is relevant.
Having considered the decision of this court and upon hearing the London Council for the parties, where the view that the death of the main accused does not result in abatement of the trial. That is the main thrust of argument in my learned friend, lords. I admire him, lords. I also accept that he is very persuasive, lord. But this law stands on his
One question, my lord. Question remains. In that case, my lord, the Honorable Appeals Court, so many cases, my lord, deal with it, whether charge has been framed or not before death of the husband. In case, my lord, charge framed, then only case can run, my lord.
No. Case, my lord. Here it's only says that it only says that charge sheet has been filed, and all the accused were discharged by the trial court. Discharge.
Then the
That is
revision
not
petition
framed.
filed. Thereafter,
That is not framed. And that stage it had happened. Just read it.
But
Read one.
whether there is other offences there or not, that is my lord.
There is no.
Only 109 or other offences.
if
my
the
lord.
lordship
That would be
permits-
verified, my lord.
And it, para 4 just see. Para 4 Jitendra is noted.
And my lords, another judgment of Delhi High Court's, my lords, the same issue. It's one page. It's more elaborate, my lords. Lords, we turn to exactly to the para 2, my lords.
Yes.
The petitioner's father and the petitioner were arraigned as accused person in this case by CBI.
109. Yes.
The petitioner's father was arraigned as an accused of possessing disproportionate assets and was charged with the trial court under Section 13(1)(e) of Red Writ Section 32 the Prevention Corruption Act, and the petitioner was charged under Section 109 IPC with Section 13(2), 13(1)(e) of the Prevention Corruption Act. Then the pendency of the proceedings, father petitioner expired on 8 August 2005. Thus, criminal proceeding against him got abated. The petitioner then moved an application for discharge on the ground that he could not be prosecuted under the Prevention of Corruption Act in view of the fact the public person charged under the Prevention of Corruption, his father, has already died. The petitioner placed reliance on the judgment of the court so and so lords. The Lord Special Judge, relying on the judgment of Supreme Court in Vakil so and so lords, held that the abatement to an offense corruption by itself a distinct offense for which a charge could be framed. The accused petitioner Siddharth Dharma was summoned by the court on the offense so and so lords. His father was found indulging in corruption, amassing wealth during the period of 23rd July to 64 to so and so. Then lords may skip all these things. Lords may then lords. Then, in other words, the abator is in possession as the LR, lords, all the ill-gotten money amassed by his deceased father, lords. Considering all this aspect, the appellant was charged under Prevention of Corruption Act dated Section 109. I consider the Lord Special Judge
Yes,
right.
I read it. It can't be wiped out.
But that is one aspect, my lord. I will verify my lord. This case, my lord, is that
You verify this, check it up.
while disposing the case, Supreme Court, my lord.
You verify this is main.
Another my lord, point is, my lord, the Sonalta case, my lord, 109, my lord, not made out against the petitioner, my lord. That is my regarding the Bhajanlal case and other cases. In Sonalta case, your lordship judgment.
And in
My judgment, I know that.
But is there squarely applicable this case, my lord.
But here you had your own defense.
Own defense, my lord.
You have a defense. Then
Yes, my lord.
you have to have a defense, then you have to prove it.
Then, lordship
In
don't.
Sonalata, I have only said that if the wife doesn't have any defense,
My lord.
if says that the entire money
Well, it's
belongs to
fair.
my
They
husband.
have dismissed.
Page 3, he fairly admits, page 3, para
No,
4,
they have
the
disciplinary
petitioner
defense,
was
my lord.
engaged in the
I
cloth
stated
business
that I am income.
and has submitted income tax returns and
They have disbelieved that. That is the fact.
Mr. Raghunath, today you are in firing range.
At the outset, I said I want
You ask for an adjournment.
solidarity, but
No, what happened in this case, my lord? Actually, my lord, they have not they have disbelieved my submission the defense, my lord, and submitted they have stated that I have filed the fake income tax
and
returns.
lordship
That did not accept my contention.
and if
And
lordship
succeed.
permits me, Lord, the third
Why
one,
not?
the hard one which will be before him, lords, let him tide about that situation. This is another judgment of this honorable court, my lords. In Nalinkant Muduli's case, CRLMC number 1915. Here, the Supreme Court judgment was cited, my lord. And what's the ratio, my lords? The court is a considered view that the prosecution is based on the allegation of corruption and acquisition of disproportionate assets by the principal accused and the petitioner being the abettors. And on the death of the principal accused, the jurisdiction of special court is not divested. The very foundation of the charge is that the petitioner abetted the principal accused, who allegedly acquired and amassed a disproportionate asset and with the ill-gotten money, my lord. And in this case, the Jitendra Kumar cited, my lord.
Now, that case, my lord,
Jitendra was considered and this honor cross taken.
and that case charge already frame other offense IP offense are there.
Distinguishable, the factual aspect, the
120 other
factual
offense.
aspect was.
The real issue they try to appreciate. Is Sonalata, I have said that if the wife simplicity says that I don't owe anything, it is only my husband who has purchased everything on my name. I am a housewife. I don't have any defense.
Conclusively,
Okay?
he is not a abettor.
He is not an abettor because everything has to be proved by the husband. That's why 109. But here he is portraying some other fact. What he says that he put forth a defense. She put forth a defense saying that is my property. But you didn't believe it. You say that no, it is not your property, it is your husband's property. So if the husband goes and you can't bring section 20, Presumption, because you are not trying in PC Act, you are trying in 109. Who's the rebuttable presumption? Had it been a presumption, then he would have proved that case on presumption. Now you have to prove the case. You don't accept his defense, saying that these properties are mine. So in that situation, how will you deal in Sornalata?
The Sonata case, Lordship held, my lords, is absolutely the husband, the wife's relation, the main accused and abetted relation is the feudalistic notes.
You have said that is your case now.
Exactly.
And
you say that none of the properties of your husband is your property, it is your husband's property only. That's what your case.
And his case is
If that is the case, the husband can't prove. Then he is out.
Then, my lord, then I will address your lordship on that point. Lords.
So in that front, you have to distinguish Sonalata. In Sonalata, what I said, the wife has nothing to prove. It is only the husband has to prove. So therefore, they let the husband face it.
In 160 statement,
and today it is a reverse situation.
Correct.
So therefore, you examine. This exception we can, because the husband has died.
I got a lordship, a formulated point, I got it. I'll come back to your lordship.
So that is the important thing. Okay. Please sit for further hearing. Yes.
Subject.
Further hearing.
Subject.
You also get some judgment on the situation.
I have got the point, my lord.
Because see, on the basis of section 20 PC Act, you can't be tried because presumption cannot be drawn against you. Because PC Act goes.
Inference can be drawn.
PC Act goes. So only 109. 109, they have to prove their case, prosecution case. What prosecution says? None of the property is your property.
Exactly.
Whose property is this?
Husband's
Husband property. Even if they prove it is husband property, then you are out. So therefore,
that is the
to what extent in the absence of yes, there in that way you examine.
Mr. Rogada should be happy for this particular point. He'll go back with a flash of smile on his face.
What is the crux of the case, my lord?
And that throws a rays of hope, lords. And in fact, he should be happy.
Well, you can get some point.
I come back to your lordship with you.
Yes. Yes. Where is the envelope?
My lord, that order was passed by the other sciences. That is the someone, my lord, the warrant. 75.
This is warrant,
My lord,
warrant issued on
23 September 2000.
23 September.
That's on cycle.
Yes. What is this case? Let us. I forgot it now.
My lord, that matter has already been settled, my lord. And the marriage of the girl victim was fixed with another boy. And if a lordship go through the 161 statement, he has stated nothing, my lord.
Yes.
But after
this POXO is there.
POXO is there. After some days, my lord, on the pressure of the parents, he has submitted some other facts. But when he rescued by the police, my lord.
She is already married with whom?
No, and then her marriage was fixed with another man. Due to pendency of this, my lord, there is a difficulty.
Who is the petitioner here?
Petitioner is the my lord main accused.
Notice was issued?
My lord. And
you are absconding or in custody?
No, I am absconding. No.
Okay, right on. Then shall I dispose it up, saying you
Your lordship has said that your lordship may direct me to surrender, and your lordship has observed that the matter has already been central compromised, and
your lordship,
both the victim and also the informant doesn't want to proceed with the case. So once surrender, taken to my bail may be considered.
Thereafter
maybe pass my lord.
Passing POXO is there, I can't do that. Investigation is still going on.
No, charge sheet already submitted.
Charge sheet filed. Charge sheet filed. Where is the charge sheet filed?
My lord, charge sheet submitted on.
Yes.
Your Lordship, page 13, madam.
Then she will go and depose in your favor.
Depose in favor. So once bail.
Bail is the only problem.
Bail is the rule. If your Lordship may only adjourn the matter, if your Lordship adjourn the matter, the Lord.
What I'll do is, I'll cancel the bail. I'll ask you to go and appear and record everything so that you will get the bail. Thereafter, you move, let the girl appear and
My lord.
she will not support the prosecution case and you are out.
Yes, yes.
That's the best way of
Yes,
doing it. Right. Petitioner is an accused in the FIR number so. Allegation against the petitioner to so. After investigation, charge sheet has been filed in the present case on 30th September 2023, showing the petitioner as an abscond. Mr. The party learned counsel for the petitioner taken me to the statement of the victim and recorded under 161 CrPC. She inter alia has stated in her statement. Where is that statement?
Madam, put page 23.
What she has said?
She voluntarily left and they handed over me to the policeman.
Stated that while she had been in relationship with the petitioner, she had voluntarily left with the eloped with the petitioner. Petitioner subsequently when Thakur Sasu, Honi Sasu, what are the exact sentence? You know, ଘରକୁ ଯାଇଥିଲି ଏବଂ ତାଙ୍କ ଠାରୁ ସେଇଦିନ ଯାଇ ତାଙ୍କ
both went to the sister's house, madam.
ସେଠାରେ ସେ ମୋତେ ଛାଡ଼ିଦେଲି ଯାଇଥିଲି ତାଙ୍କ ଭଉଣୀ ଶାଶୁ there is no sexual assault.
No, but after 7 days into 164 he has started.
161 she has stated that she looked with the petitioner and stayed in the house of the sister of the petitioner. Subsequently, when her statement under 164 CrPC is recorded, she has improvised her version, as a result of which section 6 of POCSO is invoked in the present case. Since the petitioner has been absconding on what is the date? NVW
23/9
on 23/9
2023.
9/2023, the court below has issued NBW against him. Mr. Tripathi led counsel for the petitioner on the instruction submits that the petitioner will appear or surrender before the court below on or before 31st of January 2025 and resort to the remedy available to him under law. However, he submits that if he makes an application for grant appeal, the same shall be considered on the same day. Liberty is granted to the petitioner to make application before the trial court on all the grounds and on all the grounds as has been raised in the present petition for paying for a bail. Mr. Tripathi further submits that the parties have settled that issue. The victim girl, marriage of the victim girl has already been fixed. But for the continuation of the present case, the marriage perspective of the victim is also getting affected. The counsel appearing for the informant has also reiterated the same aspect. In nutshell, both the counsel submits that the parties have settled their dispute. Hence, they conjointly praying for quashing of the FIR. And it is accordingly, I am not inclined to entertain this petition at this stage. However, liberty is granted to the petitioner to appear or surrender before the court below on or before 31st of January 2025 and move appropriate application for grant of bail. If such application is moved, the same shall be considered on the same day, same day. Petitioner is at liberty to raise all the points before the court below. Till then, no course of action shall be taken.
One line, but while considering my bail application, the observation shall be taken into consideration.
The same shall be considered on the same day, taking into consideration the observation made by this court. Yes. At least you will be out, and thereafter you do what?
Now depose kar dele, sorry, okay.
Because of the Supreme Court judgment, now it is very
Yes,
difficult. Otherwise, it could have been caused.
So marriage hai gele hai jayta.
So, anyway, yes, this one.
27, in this case, the hearing was closed. And I was directed to find some pieces of.
Yes.
I got the copies also, but again, I humbly submit, Lordship brought it extensively, Lordship know the intricacy of everything on all aspects, but at the end of the day, Lords, if a Lordship acts mean, Lords, two persons the same name, their locality is same, one person was paid, and when he was actually refunded, there is no pecuniary loss, neither to the state action nor wrongful or gain and Lordship dispute.
The mistaken belief, there was no means there. That much only I can say. I was serving in Bangalore. I was never at
That postpion came to the Cuttack residence.
No, the only problem is
I got it.
that's the problem.
Some kind of your Lordship highlighted that to me. Correct, Lordship.
I find some decision your Lordship has issued from help me.
Keep it along with the file. You have hard copy. Keep it along with the file. Put it on 28th. 28th. I'll give dictation here and now. There are a lot of things which is accumulated. I don't want to. Today, I inadvertently again I accumulated 3-4 cases.
So Jenna will laugh at me, but this is another extra sugar on the same milk.
At 28th, I'll dictate here only. I try to dictate here itself so that I see if these judgments will help you. I'll pass it. There is no serious objection. Because the only thing is there is no pecuniary loss.
No. And secondly, in the peculiar factual aspect involved in this case, two persons having same name, same locality. One was provided with a particular check. And when
see, the only thing is, he is not a criminal. Basically, the temptation of money, he procured the certificate copy and gave it to the money. Thereafter, he realized that I am committing.
Flesh and blood is difficult to resist those temptations.
So he couldn't resist. That's the problem.
Receiving a check of so many in favor of Sangram Das.
When they realized, then he gave it back.
I put myself in this shoes. Suppose I get a check of 17 lakhs rupees in favor of Sangram Das. Why should I disbelieve from Petin side and my family member receipt post
and father's name, everything is same. You take thereafter when you realize you refunded. That's the long and short of the matter.
Exactly, lawsuit. It's the main issue.
I'll give dictation on 28 here. Yes. Yes, Mr. Janao.
I'm 19.
Huh?
98. Item 98.
Yes.
There are two criminal appeals, my lord. One appeal is 59 of 2011, my lord. That has been heard by your lordship. And rest and another criminal appeal, my lord, that is 13 and 18 of 2011, not been heard because of the counsel who has been appointed amicus curiae is not doing the argument.
I have appointed you.
Yes, my lord. Your lordship has appointed. I've already filed.
He's ready.
Written note of argument.
Let it be in the list. I'll hear it because he's ready.
Yes, my lord. And 59 written note of submission and list of dates already been given, my lord.
Yes. 99.
Mr. Jaina has come all the way from Delhi.
Sahul.
In fact, he was waiting the entire day.
Yes, I know, but what?
No, he also understands the predicaments of this one.
The pressure is huge. Which matter you're talking?
98.
Okay.
98. 99 years,
Give me, see, in any case, 4:15 I have to get up. because
Let me try for 7-8 minutes. Then,
because-
99 vigilance. Is it an appeal?
Yeah.
More charge and I sorry.
No, let me argue, you can revert.
give, since he has
So
come
I'm giving
for
you-
5 minutes, because 15 I have to get up.
Please.
I have to, there is a meeting. Yes.
Here is a case.
Before my lords, my senior stars, my lord.
Regarding 98,
98, I am keeping it. And let it be there on the board. I may take up tomorrow or anytime. I'll take it up.
In the an item 98, one predicament is that, my lord. Lordship may see the order dated 28/11/2024.
What is it?
My lord, that in that para 3, my name does not reflect, my lord, my father's name gets reflected. Para 3, that may kindly be.
Your name resembles with your father's name, what to do? Change kar do. 98. huh?
Name is a very sensitive issue.
Para
Para 3, my lord.
Para 3.
That may kindly be modified to that extent.
Name of a person is very sensitive issue.
In case of Nityananda Buriya, Nitya Brata Buriya. That's the difference.
Distribution.
Okay, Nityananda para A order 28/1/2000.
2011. Yes.
ಇದು ನಿತ್ಯಾನಂದ ಬೇರೆ ಹಾಕಿ ಅದು ನಿತ್ಯ ಬ್ರತ ಬೇರೆ ಹಾಕೋದು. Yes.
98 ରେ ମୁଁ ବି written
ନାଇଁ ନାଇଁ ଆପଣ ଯେତେବେଳେ ଆର୍ଗ୍ୟୁ କରିବେ ଶୁଣି ଦିଅନ୍ତୁ. Yes.
କାଲିକି ରଖନ୍ତୁ.
Next week, tomorrow is half day. Yes.
At that time.
Yeah. Very difficult. Yes.
May I please tell us?
Hmm.
Here is the case. Goes around.
Oh, you have only 5 minutes to tell me what is the fact. Yes.
May I prepare a written argument and supply copy to my.
You tell me the overall facts.
So that is, there is only.
You keep the written argument so that while arguing, I'll note it down. That will be easier for me. Yes.
Here is a case only against me, that the person who is appointed by the superintendent. Superintendent is not the authority to appoint a person. So that's why his salary was stuck up for 5 months. And CDMO, being the authority, he asked the explanation from the superintendent how he got the appointment. And he stopped the salary. That very superintendent give his answer, he is not the authority to appoint me. So without power, he does.
What are you working for?
I am a clerk.
Clerk. Okay.
I am a clerk. And I am in deputation. I have no role to give his salary or release his salary. But CDMO is the higher officer. He has refused to block the salary. And he has questioned the very authority of the superintendent for the appointment. How he can get the appointment. So that was there in this cloud for 5 months, and that is all records are there. Moreover, superintendent is not an authority. So there is no iota in the total prosecution case except that complainant that there is a demand also. There is no demand. So our Supreme Court has in several judgments. I have quoted so many judgments also in my written argument. So without that, presumption has to go along with 7 and 13. It cannot go alone. That's like in 130 NI Act. That there has to be a legally enforceable liability. Otherwise, that presumption cannot work. So here, neither I have the authority, nor I can give you any favor. So I have taken the dictionary meaning of the bribe. So I have not prepared that also. So I cannot extend any favor. Neither I can give.
That you can't extend any favor. You are not capable of doing it. You are not authorized to do it.
Yes.
Still, you have done it.
No,
Therefore, 7.
That also.
Therefore, 7.
Then on top of that, there is a no valid censor superintendent that has been admitted in procedure.
See, 7. Why 7 means if you are you are a peon working somewhere, you will tell someone that I'll get the work done, which is supposed to be done by the head of the office. Then also 7 lies. You are not capable. You can't say that I am not capable of doing it. Why should I ask? Why should I believe it?
Demand. That has to be demand. That demand has to be proved unequivocally. So without that proving that demand independently, that cannot go. So coupled with
Demand is sine qua non.
Yes.
Yes.
Then top of that, apart from this, there is a valid censor. Whether there is a valid censor or not, that for nothing. So
Who is your appointing authority?
CDM.
Okay.
And city, that there is a judgment, my Honorable side, that if you are a prejudice or not. That the very superintendent who appointed that person, both are knowing each other that he appoints him that person, and the salary has been stopped by CDMO. So the superintendent gives the prosecution. So that is not prejudice to me. So I'm afraid to understand how is that, how do I produce that?
Then you are questioning the sanctioning authorities power.
Prima facie, the record itself, it is not there. So it can't be. That is section 19 is very clear about
Yes.
that. So I'll not travel on that because we are not seeing so only cases that. Only thing is 7, even if I pay, I am sure that I'm not paying 19 also. But 17, 13, and 20. There is enormous judgment. I've cited so many recent judgment in 7 judgments. Why it has been said that it cannot, without valid demand, without any authority to do so, that presumption 20 cannot go. So it cannot be a solo section, it has to be read with other section here. Unlike section 19. Section 19 can go independently. Even if we have reached whether the section is valid or not, that has been decided by your lordship, this court also in Supreme Court of India. So that is the case here. So
The LCR has been called for each year.
It is yes.
It is here. Let these 98, 99 were retained in the board. Retained in the board. Let's see. We'll retain in the board.
Okay. Any date of your lordship so that
Yes, it is written in the board. Government. And what about 100? 100?
Item 100, my lord.
Yes.
Lord, in fact, I have come against the conviction order, but conviction under section 409, 468, 477, and section 120B of the Indian Penal Code, read with section 13(1)(c) and D, and 13(2) of the PC Act. But in fact, though the paper book has been made ready, but the exhibits, in fact, are not there in the paper book. What I humbly pray, my lord, your lordship allows me to take, I think the LCR has come.
Yes.
To take the exhibits in the pen drive. And I will prepare 3 sets of exhibits of the paper book of the exhibits. One for my lord, one for myself, and one for the my lord, prosecution.
Briefing.
And once.
Yes, I'm giving that direction.
Yes.
100, the briefing counsel of Mr. Suresh Chandra Das, senior counsel, is permitted to obtain the soft copy of the TCR, and prepare a paper book and circulate to the council appealing for the vigilance, and additional copy for the court. Yes.
And lordship may call this matter in the last week of February, my lord.
Yes, February last week. Okay.
Like,
Thank you.